Your lordship's leave, may I mention one matter? This is an appeal for hearing. I'm praying for inclusion, my lord. Earlier, the direction was.
Yes, give it. Yes.
I have your lordship's kind indulgence to mention item number 7 of today's list, my lord.
Yes.
Original side, non-commercial, my lord.
Original, non-commercial. Yes.
Lordship will kindly take the last order passed in the matter, my lord.
No, why are you mentioning upon notice, Mr. Shikushal?
Yes, for correction.
For correction? No. What correction? Then let it be listed as to be mentioned.
It is already appearing.
Yes, but then other side is not here. Let it come as to be mentioned on Monday. We'll correct it, whatever correction you require.
If the matter is called on today, my
Yes,
lord,
then also.
my lord, we'll pass a one-liner, my lord,
Yes.
and then lordship will start hearing.
Sure. Yes.
Deeply obliged.
Appellate side mentioning.
May I be allowed to mention a matter for inclusion in the list? It is an application under section which is arbitration.
Any other mentioning?
Original side commercial division, item number 1.
This is my appeal. But from an order by which my vacating application was dismissed and the order of injunction was confirmed.
Metravi and?
Meti-Riva. Plaintiff is Metravi, I am the defendant, I am Meti-Riva. These are industrial batteries. Suit for passing off. Here, the plaintiff.
Let us see the packaging. Show us.
If I may seek short pass over, my lord. My senior is on his leg.
Who is your senior?
Sir Harsh Tiwari, Shushya Mitra.
Pass over.
Item number 2.
My pleasure. This is the above brief.
We raised a initial point of maintainability of the appeal. Because there is an appeal from an order passed in the commercial division, and the order passed is not an appealable order in terms of order 43.
Commercial books.
What appeal is this?
My appeal.
Answer the point of maintainability first.
Well, I answer the point of maintainability. I raise a point of, my lord, constitutionality of the constitutional challenge towards, my lord, the fact that the commercial court of the High Court is a creature of statute and not a High Court under the Constitution of India. And, my lord, there are 5 commercial courts in West Bengal. And from each commercial court, an order which is not appealable, the jurisdiction of Article 227 is available to a petitioner. But from the commercial division of the High Court, the 227 jurisdiction is not available to a petitioner who is before the commercial court. Therefore, my lord, there is a violation of Article 14.
So in this proceeding, we will declare something to be ultra vires.
No, my lord, till this Honorable High Court sets up a revisional power from an order from a commercial division of the High Court, my lord, this appeal is maintainable according to me. Because I am remediless.
You are not remediless, Mr. Laidi.
But I am not remedial. SLP, my lord, the only chance is, my lord, is a special leave petition.
Correct.
But there is a leave, my lord. That is not under 227. The Supreme Court, while determining the special leave.
Anyway, don't argue this point. We are not accepting your point. Anything else? This is not appealing to us. Anything else? It's very hot outside.
May I understand? But we are remediless, my lord. Otherwise.
Go before the Honorable Supreme Court. কি করেছে
But-
dismiss করে
My,
দিয়েছে?
my kindly see the order, my lord. And my lord, again, my lord, my second limb of argument is, my lord, what has happened is my written statement has been taken out of board.
Oh, your client took recourse to falsehood. I remember now.
No, my
Falsehood.
client didn't take recourse to falsehood. My client did not take recourse to falsehood.
Who wanted to file? Who wanted extension of time to file written
I
statement?
wanted to, only one paragraph in the affidavit, in the petition,
Was false.
was false.
Only one.
No, man, false, man, false not to my knowledge. Man, false not to my knowledge. My advocate told me that he was unwell. Well, on that ground, my lord, my written statement. And my lord, my-
Right. The problem is there are at least two coordinate bench judgments saying it's not appealable.
But my lord, nobody has taken into consideration this argument.
Also Supreme Court.
But nobody has taken into
Go before
consideration.
Supreme Court. We are bound by the Supreme Court.
And my lord, my second point
Give us
argument.
that decision.
2018 volume.
So go before the Supreme Court.
My lord, second,
Argue
my-
constitution.
the second limb of my argument is, my lord, this order of dismissal of my taking out my written statement is akin to order 7 rule 11 of dismissal of plaint.
Mr. Lahiri, today Supreme Court had said this is not appealable.
Even if it is akin
No,
to
it's
order 7
relied
rule 11,
upon by
then
the
also
coordinate
it will be
bench
a-
and
it will be a
Delhi
deemed
High Court
decree,
and
then
Bombay
it will be
High
a regular decree. Then it will be a regular appeal against a decree.
Yes. So this is an appeal against that. My written statement has been shut out. It is same as, my lord, my
Shut out be akin to a rejection of plaint.
yes, I am defenseless.
Too hard to
I
defend.
become defenseless, my lord, in this matter.
You want to press your appeal, or you want a rejection, or you want a withdrawal? You have that option.
Let me ask.
Ask. We will say that this is not maintainable. Therefore, without going into the merits, we allow you to withdraw if you want to withdraw.
We will get the time to it.
Issue. This appeal is directed against a judgment and order dated March 24, 2025, whereby a learned judge of this court dismissed the appellants. There's only one appellant.
One appeal.
Dismissed the appellant's application for extension of time
application,
Paragraph 30.
if allowed or disallowed,
Supreme Court.
Though in arbitration, it deals with interpret
Thir-
section 13(1), my lord.
about even a complete mess.
No, no, I
এটা এটা ফাইল শুদ্ধ পাঠাবে
out of
হ্যাঁ এই জাজমেন্ট শুদ্ধ ফাইল শুদ্ধ পাঠাবে হ্যাঁ হয়ে গেলে পরে জাস্ট এগুলো অ্যাড করে দেবো আরো একটা দেবে হয়তো সেটা
demand for
That is so different.
হ্যাঁ।
That is a totally different case.
এ কপি করে রেখে দিই
From Krishna Rao. They can recent judgment.
চলো নেক্সট
Oblige, my lord.
হ্যান্ড ওভার দি জাস্টিস সেন
Procedural Matter, item number 1.
Well, I'm for the appellant. My lord,
Who's for the respondent? You are for the respondent?
it's for the My lord, it's a appeal arising out of a final order. But my lord, generally, my lord, appeal arising out of a final order, I wouldn't have prayed for a stay. I would have asked for your lordship, my lord. Here, my lord, it's an infringement and a passing of action, by which, my lord, not only my business has come to a standstill, but secondly, the receiver has gone and has taken possession of materials, my lord, which were not the cause of action of the suit.
Show us the packaging.
Lordship. My lord, this is the plaintiffs. This is the defendants. It's a case for passing off. It's not a case for an infringement. Both are registered.
The learned judge has been swayed by the phonetic.
Yes, now that is the
Similarity.
reason, my lord. I'll just like to show your lordship, my lord, the order. I would only show the order and a few documents from with relation to the order as to why it is not only bad on the face of it, but if I may be permitted to say, my lord, to a large extent perverse.
Sure, sure.
I'll just show the order, my lord.
We have read the order. You show us the
Lordship.
documents.
Well, I'll just indicate, my lord, with the order, the documents. Why I am saying that the order is bad. My lord, if your lordship, my lord, comes to
Take your seat, Mr. Tiwari. You want to say some preliminary objection or something?
I only wish to say that the samples that have been shown to your lordship, with the utmost respect, are not representative samples.
Not representative.
Because the
Do you have
claims-
samples?
My lord, the issue is that the samples that we had are already part of the record of the learned single judge. So,
my lord, the
we have
sample,
not been able to
my lord, I'll correct
your
him.
lordship.
My
Let us call for the records.
But only one thing, Malad, the sample that they had shown was the only one sample which they had got from Amazon, which we are not selling.
My lord, that,
Our packaging is
that
this.
has not been-
Our packaging is
We'll
this.
call for the first court records. We'll call for
But
the
I'll
learned
not
judge.
do that only. Malad, today, Malad.
Mr. Basu, it's very important for us to see
Lordship, correct.
the real products, the packaging.
But this is the product.
Your client
which we
will
are
be
using.
showing us something which may not be very similar, deceptively similar. So why don't you produce tomorrow or
Certainly, my lord.
Monday?
The issue is this, that we had filed an application under Order 39, Rule 2A.
We have read it, the judgment. We know, Mr. Tiwari.
Because of that, they've stopped selling these items online.
Right.
So for us to be able to acquire them all over again, we will have to produce it from the learned single
So
judge's
is-
record.
Very well, then we'll call for the records. Hey, Kaushik, সোমবার দিন রেকর্ডসটাকে আনিয়ে নাও হ্যাঁ কাম ব্যাক অন মানডে
Very
মিস্টার
well.
বাসু অর্ডার দিতে হবে না নট টুডে করে রেখে দেবো
But if your lordship Malad, passes an order
Yes.
calling for the records.
This appeal is we should record an order, of course.
Malad, only one more thing, Malad, the receiver had taken possession of those which are in the custody of the receiver. So the receiver can also produce. The receiver ko product
Both. Let us call for the trial court records, also the receiver.
Learned receiver was discharged, my lord.
No, no.
Oh, discharge. So where are those things then? Lying with whom?
Where we have put stickers to the effect that this has been seized and is custodial
So
allegiance.
then you can produce it.
So
If my lord gives me the permission,
Yes.
then to go back
কি করবো
and produce it from those samples.
আগে রেকর্ডটা আসুক Correct.
We will also communicate this order to the receiver, then he can.
This order, this, I'll record that. This
Was better than the bar, my
all right.
Item number 3 and 4.
Lordship, I'm being led by Mr. Ray. He's on his legs.
Mr.
Aniban Ray, he's on his legs. A short passover I'm seeking for.
What passover? This is the only matter left on the commercial side. Okay, passed over. Make a second call.
Our passover matter, I get over here.
Passover matter item number 3 and 4.
Correct, correct.
On the last occasion, like I'll start your lordship, I'll introduce it.
Non-counsel.
Lordship,
You are for the, you are for?
I'm for Lara Manning, your lordship.
Lara.
Respondent, your lordship.
He's come.
Sorry.
Unless on the last, sorry.
Yes, assignment of arbitration clause.
As I was submitting, on the last occasion, I had only shown your lordship, that is more or less on the facts, because your lordship was of the view that I should also deal with the facts. I tried to demonstrate that this assignment was not of the entire contract, but it was in part, as in only the receivables and the security interest in the secured properties, and not the rest. Kindly appreciates things, that is the scope of the
Main agreement was between?
I'll just refresh. Main agreement between Srey and my client.
Lara.
Lara.
And settlement agreement between?
Srey and Kobelco.
And Kobelco.
This the agreement.
So there was due from Lara to Srey. Lara to?
That due has been, according to them, assigned to my learned friend's client.
Because there was also due from Srey to Kobelco. So it was a mechanism to pay off Kobelco.
Other reason for that,
Achha.
Malad, what the reason was, I'll just point out in a 1 second, Malad. Malad, this happened in March, July, and Malad in October, Malad, the RBI took it over. Stray went into Malad, the CIRP process. So what happens, Malad, if it goes into CIRP, it's proportionate what my learned friend will get. So therefore, before that could happen, one of the executives have been linked and sent to Obilco. This was the problem, but I'm not challenging the legality of that. Maybe this is not maintainable because the NPFC company cannot give a assignment like this. But again, this is not a question which your lordship will look into at this stage. I might take it up if your lordship refers or it's referred to arbitration. I will take it up there if required. Now, other than that, Malad kindly appreciates. Here the question arises when your lordship in that agreement finds there is something to show that was a part assignment. If I take the word as part assignment, if that is the case, Malad, then in that event, your lordship will kindly consider that whether there was an requirement for express assignment of the arbitration clause.
Specific.
And there, Malad, to join, Malad, both the things together, Malad, the question of incorporation by reference has to be also in express terms.
My brother does a lot of reading.
I have been on the wrong end of him, Malad, in many occasions, but I know, Malad.
There's a very recent Supreme Court. You should both consider. As we read it, it favors you.
But I'm very grateful.
2024, 7 SCC, 174.
Then look into it. And then may I come back?
You also consider.
Then in that event, Malad, only one submission was. The lordship had decided minded to fix the next year on Monday.
Yes.
But if you put your Thursday, when Thursday,
You are going to teach.
Yes.
But I'm looking forward to it very much. So that's why I'm saying.
We are both envious of you.
But I'm envious of myself, Malad, because I'm getting the.
No, the weather. You'll get fantastic
Malad,
weather.
it's very good, Malad. 17, 18, Malad.
Fantastic. That is why we are envious.
I think the lordship was also. But I wanted to teach in the Calcutta University. They rejected me. So now I'm getting some chance elsewhere.
Thursday করে দাও, Thursday করে দাও.
I'm very grateful to your lordship.
Much. First.
Well, we have, yes, good.
First. Much obliged.
এই তোমার ওয়ার্নিং লিস্ট বেরিয়েছে তো আজকে অ্যাপেলেট সাইড অ্যাপেলেট
একুশ
We expressed our mind yesterday.
Yeah, your lordships had expressed your lordship.
May I seek a small passover because okay then.
My lord, our instructions are this, my lord, that if they are ready to give up prayer C, my lord, that actually does not, my lord, inure to, my lord, my client's difficulty because my back is against the wall. This injunction which is operating against me, my lord, is so harsh that I'm suffering a colossal loss on a daily basis. So, my lord, my instructions are, my lord, Mr. Mitra will come and submit. I'll start. Is that kindly, my lord, your lordship has not had the opportunity to go through the plaint. Because if your lordship goes through the plaint, my lord, probably, my lord, your lordship may be persuaded to do, my lord, think otherwise. Because
Mr. Judge, we appreciate your difficulty. Facts are ugly. We have gone through the papers. Facts are ugly as far as your clients are concerned. Anyway, you have to do your duty. You argue your case. Why we expressed our mind, we were just wondering that you'll lose a forum.
I appreciate that, my lord. I lose a forum. But, my lord, the thing is this, that if your lordship sees the plaint, the prayers in the plaint, and the injunction that has been obtained, my lord, it has no connection. Number one. Number two is, my lord, what is troubling your lordship maybe as to why your lordship feels the facts are ugly, that a trust estate is being mismanaged. Probably, my lord, that is what is troubling your lordship. And probably this property, this development of the property is probably, as I say, your lordship is being done in a manner which is not supported by. But, my lord, what has not been told to your lordship is that so far as the management of the trust is concerned, there is already another suit pending. That suit, my lord, has been filed by them for management of the trust, in which, my lord, the injunction was not granted. This suit is a subsequent suit. In this subsequent suit, my lord, what they have done, they have put in everything in one basket, trying to create a picture as if, my lord, this development. In that first suit, I was a party. We were not parties in the first suit. We have been roped in, my lord, only for the purpose of stopping this construction. Now, so far as this construction is concerned, and so far as this development is concerned, my lord, my respectful submission would be that my learned friends do not hesitate in admitting the fact that the property is outside jurisdiction. Prayer C, which my learned friend is trying to give up, which was troubling your lordship, my lord, is neither here nor there because that is the subject matter of another suit. So they will be able. Prayer C is for declaration of management of
Right of reply, Mr. Bhattacharya.
Yes. So, my lord, that, my lord, I believe, my lord, would be available to them. But so far, my lord, as development is concerned, your lordships have held, my lord, being a party to that a developer also has an interest. This development agreement, which is, my lord, been agreed into between the parties, my lord, is been going on. This development was already going on from 2019. Knowledge, I'll come subsequently. But the fact remains that this developer in the plaintiffs admit that this developer has an interest in the constructed area, which has already been constructed. Now, the question is, there is no question of title involved over here. The question is, the suit for land, that criteria is right title, interest, and possession. Title may not be the question here because specific performance suit, there also probably, my lord, title may not be the question because the person proceeds on the basis that the agreement, under the agreement, the vendor has the title. But right and interest, my lord. But right and interest is something, my lord, which, my lord, would also tantamount to, my lord, a suit for land. And, my lord, that has already been observed and held to be a suit for land. So, my lord, I would try and persuade your lordship that so far as the other prayers are concerned, they also tantamount to, my lord, release pertaining to property, or at least deciding my interest in respect of immovable property outside jurisdiction. Because the prayer is not for specific performance over here. Prayer is delivery of and cancellation of the development agreement, under which I have a right in respect of the immovable property outside jurisdiction. And that is the primary object, Millard, as would appear from first prayer to the last prayer of the plaint. So, Millard, we would try and persuade your lordship that so far as the plaint, even bereft of prayer C, Millard, still continues to remain to be a suit for land.
Sorry, my lord. Now, kindly come to the plaint. Starts at page 68, volume 1.
Yes, Mr.
So kindly come to the first page. There are two plaintiffs, my lord. The first one is John Augustine, Metropolitan Bishop of India, Pakistan, Burma, and Ceylon. Then Indian Church Trustees, a body corporate incorporated under the Royal Charter. Kindly turn the page. First defendant
A
is
body
Abir
corporate
Adhikari.
incorporated under the Royal Charter. It is there in the cause title. Mentioned.
Under Royal Charter.
Yes.
Oh, I see. I see. Here. Yes, yes. Number 2.
Number 2.
There was a schism in the Church of England and it broke away.
Yes.
There was a Royal Charter which established, and subsequently there was a Church Act
Very well.
by which this.
Let us go by the plaint. Kindly come to the second page, page 69. Abhir Adhikari, son of so-and-so, by faith Christian, having his office at Bishop's House. Number 2, Terence Hamilton, Ireland, having his office at Bishop's House. Then, my lord, my client Srijan is not required. Kindly come to the body of the plaint. Kindly come to page 75, paragraph 12. Paragraph 12. Premises number 224, Acharya Jagadish Chandra Bose Road, Kolkata, lying and situate within the jurisdiction of Korea Police Station. Ward number such and such of Kolkata Municipal Corporation, which is more fully and particularly mentioned, described in the Schedule A, under the ownership of Indian Church, held through the plaintiff number 1. Not Indian Church Trust, but Indian Church, be that as it may. Now kindly come to
You are saying that the rights and title are vested in the Indian Church, not Indian Church Trust. Paragraph 12. 11.
yes, kindly also, my lord, come to paragraph 11 once. Paragraph 11, it is pertinent to mention that notwithstanding such repeal, the rights and title that were vested in the Indian Church continues to be valid. This is clear from relevant provisions of the General Clauses Act, etc. I am not on that also. Now kindly come to page 77. Roman 6 at the bottom. Thereafter, the plaintiffs uninterruptedly continue to enjoy and possess the said premises and are paying duty, that is, property tax, to the Kolkata Municipal Corporation year after year, every year. A certified transcript of the Declaration of 1960 was prepared by R. Islam, retired senior interpreting officer, original side, High Court, Calcutta, on 27th November 2020. The date is important. The date is important. Kindly keep this in mind that, my lord, they have documents translated in 2020. Then kindly turn the page. Paragraph 14. In or around September 2024, the plaintiff came to learn that the respondent number 3 was constructing a building at the aforesaid premises, and the Indian charge trustees were shown as the landowner. But kindly pause here for a moment. In or around September 2024, no particular date, nothing. Normal reaction, a letter to the defendant number 3, no. No complaint to any authority. Well, there is a limit of arm twisting, well, that has to be stopped. Kindly come to paragraph 15. So, September, I presume end of September. Paragraph 15, that the members of Indian Church Trustees held a meeting on 22nd February 2025, after 6 months or 5 months, 6 months. September to February, maybe 5 months. And decided to take steps with regard to the dissipation of the church property. Kindly take note of this. If this is not by a title dispute, nothing is title dispute. Dissipation of the church property without the concurrence and knowledge of the Church of India. They also authorized so and so John Augustine, Metropolitan Bishop, through a resolution dated 22nd February 2025, as signatory B, and is hereby all the assets, represent the Indian Church Trustees in the matter relating to holding number such and such. Kindly turn the page. Or after that, my lord, may I continue? With building, etc., premises number 224, Acharya Jagadish Chandra Bose Road, Kolkata, to be filed before the High Court, Calcutta, or any other district court, or tribunal, or forum, or authority, and to sign Vokalatnama, etc. Then, my lord, paragraph 16 is more interesting. The members of the Indian Church Trustees engaged lawyers, when I really do not know, to carry out searches. And upon such searches being carried out, the plaintiff stumbled upon a development agreement dated 7th August 2019. Now, my lord, I said that this English translation or the translation is important. Made in 2020. Development agreement of 2019. Steps were taken in 2020. This translation, they do not say was required for any other purpose. Has to be for this suit. Stumbled upon a development agreement dated 7th August 2019 and a power of attorney and a title report carried out allegedly by the defendants. Now they are fighting. They get hold of title report prepared or caused to be prepared by the defendants. Now kindly once come to page 467, volume 4. Subject to correction, my lord, does not appear to be a certified copy. Page 467.
The development agreement.
I said, my lord, there is a limit of arm twisting.
This is a copy of the original.
Appears to be. Copy of the registered document. Oh, the 494 বোধহয়। লেখা আছে। 494. Yeah, 494. Now kindly come to page 494. Part of this development agreement. Clause 11. The developer herein agreed to deposit with the owner
Yes.
The developer herein agreed to deposit with the owner an aggregate sum of rupees 5 crore only as and by way of refundable security deposit in the manner following. Rupees 2 crore 50 lakhs only has duly been deposited with the owner by the developer. The receipt whereof the owner doth hereby admit and acknowledge. The money goes to the trust. In any event, I do not want to rely on this. The document will say that the money 2 crore 50 lakhs, my lord, was deposited, or my lord, the trust received it. They do not know anything. They feign ignorance in 2025 after, my lord, 8, 5, 6, 7 years and come and say that, look here, we knew nothing.
Total 5 crores have got by 2020.
Then next, after registration of the agreement and within 7 days from the date of obtaining sanction of the plan, the developer shall deposit with the owner the remaining sum of rupees 2 crore 50 lakhs.
Deposit.
Money deposited. 5 crores. I do not know, my lord. The church must be filthily rich to, my lord, ignore entry of 5 crores of rupees in their accounts. But they receive it. They do not make any whisper in the plaint or in the petition that no, we did not know about this. We did not know about this receipt of money. It was incumbent on them, my lord, with greatest of respect to say this, that I am not a party to this. No whisper. Kindly come to the next document, 538, power of attorney. Registered power of attorney. Made. Registered power of attorney giving all, everything, possession, everything, to do everything.
Illegible.
My lord, I have annexed, my lord, copy of, my lord, their petition, my lord, or the, my lord, service copy, because I had to
Anyway, general power of attorney is.
to do everything. Your lordship is, your lordships are pleased to come to, my lord, page 541. At the bottom, my lord, may I read out, to obtain sanction plan. It's illegible. Kindly turn the page. To cause demolition of the existing building and structures and further to cause removal of debris which should come out of such demolition work. To apply for and obtain registration under the WB HIRA. All done. To enter upon the said property with men and material as may be required for the purpose of development. Now today I am in possession. I have constructed, my lord, a multi-story building there. Maybe partly. G+6. A building standing. Now, my lord, kindly come back to the plain, my lord.
Yes.
Kindly come back to page 79, volume 1, my lord, the plaint. Paragraph 17, my lord, it's not important. The defendants number 1 and 2 claim themselves to be the trustees. Then 18. It is pertinent to mention that the defendants number 1 and 2 are neither trustees of the Indian Church, nor under the rules of Church any trustee is authorized to enter into any agreement. Again, I pause here for a moment. Do not say, my lord, who are the trustees.
Maybe just interrupt you. Mr. Bhattacharya, just one small point. A 6-story structure has come up. It has not come up overnight. You claim to be trustees? What kind of trustee are you?
My office is not over here.
6-story structure coming up over a period of 1 year, and you do not know.
By Mr. Mitro.
Yes, difficult question, I know. So, yes, Mr. Mitro.
I can answer it, but since I've been led by.
There is no answer. There cannot be any answer. Do you live in Calcutta?
No. Well, kindly looks at the cost title. Lucknow.
Oh.
Come across a board. While crossing through that, I come across a board. Owners Indian
You are a
Church.
trustee. You can't say I did
There
not
are so
know.
many properties of the trust all over the country. My lord has seen what has happened in Supertech, a 80-story building because it was illegally constructed.
If it
So
was
the court has pulled it down.
Yes, because there was no plan. That's entirely different thing.
But here there is no. My lord will kindly come to paragraph 6C of the stay petition. That is very
Mr.
important.
Mitro, if necessary, we'll hear you again.
Paragraph 6C. My lord, kindly, have they taken the leave? Have they taken the leave which is incumbent under section 7 of the Religious and Charitable Trust Act?
Argue that in your suit.
My lord will kindly take paragraph 6C of the stay petition.
Argue that in your suit.
My lord, we came to learn when they advertised as the property belongs to Indian Church Trust.
Difficult to believe your clients. Difficult to believe your clients. Sorry.
My lord will kindly
6 stories coming up over a period of 1 year, and you claim to be trustees, huh? After demolition of the existing structures, and you say we did not know.
But when it came up, there was no logo that the property belonged to Indian Church. My lord will kindly take paragraph 6C of their stay petition. This is what they say. Kindly takes paragraph 6C.
Yes, Mr. Varsi.
Kindly comes to paragraph 6C at page 13 of the stay petition.
One is this, the delay, so to say, the knowledge and delay. The other is the developer, after all, has some interest in the property. So this is what Mr. Dutt was saying before you came, Mr. Mitro. So ultimately, it does involve right title and interest to a property situated outside jurisdiction. Well, at least prima facie, it so appears. Therefore, you argue. We'll pass an order after reserving judgment.
Paragraph 6C, my lord, if your lordship.
6 of?
6C of the stay petition. Page 13 of the stay petition. They do not, and I will show 2 clauses of the development agreement, which is
Yes.
really very interesting. The petitioners had entered, which is the developer, into the said joint development agreement.
Is it correct that the security deposit of 2.5 plus 2.5 has gone into the trust account?
Terence Hamilton to Abir Odhikar. To Terence Hamilton and Abir Odhikar. Not to the trust, not to the account of the trust.
The records will show that.
It has not come to the account of the trust. It has gone to the account of Terence Odhikari, Terence Hamilton and Abir Odhikar. But this is what I want to show from paragraph 6. This is their categorical admission and 2 clauses of the development agreement. The petitioners had entered into the said joint development agreement with the plaintiff number 2. The defendant number 4 was a confirming party therein. The defendants 1 and 2, which is Terence and Abir Odhikari, along with defendant 4 being the pro forma respondents, had categorically represented and warranted that the suit property belongs to plaintiff number 2. They admit that this is the property of the church. And defendant numbers 1 and 2 has the authority to deal with it. Nothing shown. How do they have the authority? To deal with the suit property in the manner as envisaged in the development agreement, being convinced with the representation and warranties the petitioners had entered into the said development agreement, and as a consequence thereof, possession was handed over. Possession is, my lord, not a possession, it is a license to enter to build a property. Now, my lord, 2 clauses of the agreement. My lord, this is really very interesting. My lord, will kindly take volume 4, page 455, clause 3F. They were all along aware of it.
$455.
Yes.
No, the agreement starts at 467.
Number 471.
One of them. One of 480. $485 cross 3. If the owner has full Malota 486 3F. I'm sorry, Malota. If any permission, for L, my lord, if any permission is required to be obtained from any court or authority to implement, such permission shall be obtained by the owner at its own cost. Why do they insert this? Because they know it's a charitable property. They need this permission. Otherwise, it's void. And my lord, the indemnification clause. My lord kindly takes the indemnification clause. There's an indemnification clause as well, given by the owner. Page 513, clause 20.2, 22.2, at 514.
Yes.
The owner shall indemnify and keep the developers saved, harmless, and indemnified of from and against any and all loss, damage, or liability, whether criminal or civil, suffered by the developer in the course of implementing the project for any successful claim by any third party for and on account of any defect in title of the owner in respect of the said property, and or any of its representations and warranties. Well, Lord, read it with 6C of the state petition. They were all along aware that a permission is required and this property did not belong to them. They were not authorized to represent the church. And it was done in a covert manner so that nobody gets to know. But all these churches, my Lord has seen the Jewish synagogues, the Armenian church. I have done several matters of Armenian church. All these properties have several properties. And your Lordship will kindly see, my client is not in Kolkata. My client is, one of they started advertising it sometime around last year, saying Logos property owned by Indian church. Not an irregularity can be condoned, not an illegality. And what has happened is an illegality.
I submit is this, my lord. If a property belongs to me, and my learned friend, my lord, lets it out to Mr. Shubhajit Mitro, and my lord, construction takes well, I'm just taking an example. I would love to have.
Now, which one of his properties? That's the question. I would be happy with the Shanti Niketan.
I will respectfully put it this way, my lord. Everything has been shown to your lordship. There are problems. I don't deny that. A property has been built up, 6-story building has come up. What had you been doing all this time? This issue is there, but there is an explanation. The person who is verifying, my lord, the person who is, my lord, the spokesman for the trust. He is saying that I had been in somewhere else. I had not been here. Yes, of course, a building has come up. But if ultimately it is found that this property belongs to the church and these two gentlemen, Mr. Mitro's client, I do not know what will transpire ultimately, or whoever is appearing for them. Well, they are not the trustees at all of this particular trust. Then what happens? Then what happens? I am just asking this. This is the very fundamental question. A property belonging to X has been, my lord, caused to be let out, my lord, by Y, proclaiming that he is the owner of the property. And then, my lord, relying upon that statement, X has constructed a building. Now, when A comes to know of it, he, my lord, rushes to the court and says, this is my property. How can somebody else construct on this without my permission? The person who is constructing, he comes up and says that, look, I have been constructing because I have been empowered by X to do that. A says X is not the owner, then how could he have given it to you? This is the short point which ultimately will try, on which the entire question will revolve at the time of it. This is an issue which goes to the root of the matter. Persons, or I am not going to issue the, I am not going to use the word impersonating. Two persons alleging themselves to be the trustees enters into a property, gives it to on the basis of a development agreement to a developer to develop the property. The developer starts construction on the property. The owner does not know. Yes, your lordship can say there may be some latches on the part of the owner. But if actually, my lord, the owner is the owner of the property, and he says, I did not know anything of this, then how could a building be constructed on my property? Then, my lord, can it be said that there is no case to answer? My lord, this is what I want to submit to your lordship. Apart from the question of delay, apart from the question of acquiescence, apart from the question of latches, these are there, of course. But then again, there are explanations for that. They said, I did not know of one. So, my lord, this is so, and my lord, 6-story building has come up. But what I am worrying about is this. Ultimately, my lord, if it is found that the trust had nothing to do with it, I am taking a very, my lord, this is a very big assumption. If, my lord, ultimately it is found that the trust had nothing to do with it, and these two gentlemen who had entered into the contract on behalf of the trust, proclaiming themselves to be trustees, had nothing to do with the trust, then, my lord, where do we stand? What happens to the property? In the meantime, my lord, third-party interest will be created on the property. The tenants will come, owners will come of the flats. And then, my lord, what will happen? My lord, I am just foreseeing that particular possibility. I quite fully appreciate, my lord, the problems. There are too many lions in the way, as the saying goes. But then again, my lord, I am submitting to your lordship, but this is not perhaps a matter. It's a very unusual matter. It's not an usual thing. Taking advantage of the fact that the person in charge of the trust is not in Calcutta, a property has been dealt with. Well, I leave it to your lordship to consider as to what is to be done in a case like this.
Mr. Mitra, what do you say about suit for land point?
Well, I have got twofold answer to this. This is a suit for, I mean, if the property is a subject matter of the controversy, then it becomes a suit for land under clause 12 of the legislature, no doubt about it. But if your lordship looks into the plaint is, my lord, attacking the development agreement, cancellation, rescission, section 26 of the Specific Relief Act, section 31 of the Specific Relief Act. If that is the point, my lord, your lordship can immediately pull me up, look at your prayer. Their issue of possession is there. My lord, my learned junior has told your lordship that he is perhaps not going to press the issue of possession in this court. But, my lord, if your lordship looks into the averments in the plaint, it is cancellation of the document, rescission of the agreement, because it is a void agreement. No permission.
Which will affect their interest in the property?
It will affect interest in the property. But then again, my lord, if it is simplicity or cancellation of it, and my lord, if that pleading is there, but I must frankly confess to your lordship, there is no prayer for cancellation in the plaint. Right?
No, the prayer is there.
If the prayer is there, and my lord, the pleading is there, if, my lord, we do not press for this.
Prayer C. Prayer C was, Mr. Bachawa told us yesterday that the plaintiffs are willing to give up. Prayer C.
Yes. But then, I must frankly tell your lordship, the problem is this: if we give up that, we are going to give it up. Because otherwise, if we sustain that, then, my lord, the suit goes out of your lordship's court. But, my lord, if we give it up, then, my lord, the problem arises with regard to, my lord, the prayers in the petition. Prayers in the petition are on the basis of the possession. My lord, then I will have to, my lord, pray before your lordship that allow me to go before the learned trial court, make a prayer for, my lord, injunction restraining my learned friend's client from giving effect to the development agreement. If I do that, my lord, then, my lord, I can sustain my suit.
Very well.
My lord, these are my submissions.
We are reserving order. We need not hear you. You are for?
Interest in the land.
You will be supporting Mr. Mitru. Yes.
One statement with me.
Yes.
The other one was received that is not with me. But 50 lakhs was received in the account of the judge.
Account of the
And because they have
different PAN number. Different PAN number.
No, please don't say something which is not there in the petition.
There in the petition of the
Either in the plaint or in the petition.
He's saying something which is not
No.
in the petition.
It was for them to explain.
It's already very hot outside.
Yes. That is why.
Mr. Bhattacharya was addressing a lot. I expect not the same treatment to me. But the second point is that Lord, I as a trustee has never seen him on board. Lord, paragraph 14, 15, Lord, Mr. Mitro read out those paragraphs, your lordships will find. He ascertained that the property belongs to the judge trustee. Now, my lord, if he is a trustee of the church trustee, how can he go in the market to ascertain which property belongs to the church trustee? He should know. But these pleadings in the plaintiff. But thirdly, let's not only prayer C, kindly have a look at prayer F. Kindly have a look at prayer F. Of the plaintiff.
we last prayer.
This is out and out a suit for land. Kindly come to page 19. Look, this is out and out a suit for land. This can't be saved under any circumstances. And now, Lord, kindly see paragraph 23 of the impugned order. This directly not touches on the ownership of the property. Kindly see paragraph 23 of the impugned order.
আমি চাকে দেখতে পারবো না আমার বইতে দাগ করা আছে
Kindly Lord, have a look at paragraph 23 of the impugned order. This is all we make it.
ষোলো তুই নেই
Paragraph 23 can be taken note of that the text and clearly touches on the property.
Mr. Mitra, anything more?
My lord, only one, if your lordships permit, one decision, my lord.
Yes.
I would have loved to, my lord, start from not Mulji Jetha. 1983, my lord, I would have loved to, my lord, it deals with, my lord, the Chaitanya Math, the
Chaitanya, yes, Mayapur.
It deals with very categorically that anything, any interest, any touching the property.
It's a revision bench.
It's a revision. And my lord, one Supreme Court judgment, my lord, may I show you?
Was it Justice M.M. Dotto? No. Who was Chaitanya?
No.
No, that you were referring to a single. This is Chaitanya suit for land.
No. 420. Justice Dutt sitting with Justice Manoj Kumar. Very detailed discussion.
Hey, 83 Calcutta page.
420, my lord. May I give
what?
Yes. Please. Thankfully, that action is not there.
Very well. Let us reserve the.
And my lord,
we will not reserve judgment. What we will do, we'll place it as for orders. Tuesday on Wednesday.
Few paragraphs from my lord, one judgment.
Yes.
Sorry, my lord. Okay. 2016 too.
Solo 3 years.
Kindly come to the second paragraph. Paragraph 2. May I, sorry.
Yes.
The facts which are essential to be stated are that the parties to this lease entered into an agreement on 28 February 2008 for development of the land of the respondent. As per the said agreement, the appellant was required to develop a residential project and/or commercial complex and/or multiplex and/or hotels and/or malls, etc., as permissible in law. The respondent had handed over vacant possession of the land to enable the appellant to start the development work. Clause 13 of the development agreement contains an arbitration clause whereby the parties had agreed to refer the matter in respect of any difference or dispute between them with regard to the construction of the term of the development agreement or with regard to the project undertaken for arbitration. A memorandum of understanding was entered into between the parties which stipulates that the development was required to construct a township project, etc. Then, my lord, paragraph 4, arbitration, the arbitration was required. Kindly come to paragraph 5. The learned single judge scanned the anatomy of clause 12 of latest patent and various decisions of the High Court of Bombay and referred to the decision of Mulji Jeta, adverted to the issue relating to what would constitute cause of action in obtaining factual matrix, analyzed the decision of the Bombay High Court in such and referred to ADCON, and eventually came to hold as follows. Then, my lord, the learned single judge held that it's a personal dispute, not a suit for land. That was, my lord, sorry. It revoked the leave which was granted. Then, my lord, it went up before the division bench, and then, my lord, kindly come to directly. Kindly come to paragraph 32. The seminal issue is whether on the factual score which has been exposited, the application filed under Section 9 of the 1996 Act before the High Court of Bombay can be regarded as a money claim. On a studied scrutiny of the agreement and the MOU, it is clear as day that the development agreement indubitably had created certain interest in the land in favor of the appellant. The assertions made in the application, along with the relief clause, which read in its entirety and appreciated in a holistic manner, it becomes luminescent that the court dispute pertain to possession of the land. For the appellant claims to be in exclusive possession, and the respondent, per contra, has asserted that it has taken over possession. It can irrefragably be stated that any order passed under Section 9 of the 1996 Act will have the impact on the land. It is difficult to accede to the submission that it will not conceptually fall within the category of suit for land as engrafted under clause 12 of the latest patent. It is clearly a dispute with regard to the possession, which is evincible from the correspondences and the averments made in the application preferred under Section 9 of the 96 Act. Thus, there has to be determination as regard to the possession and impliedly issue of direction for recovery of possession. Hence, the conclusion arrived at by the division bench on the basis of the scrutiny of documents that the dispute is embedded with regard to the possession of the land because of fundamental claim pertains to certain construction space and of land. Therefore, it would conceptually fall within the conception of suit for land appearing in clause 12 of the latest patent. Is unexceptional. Here also, my lord, your lordships have seen the development agreement. It gives, my lord, a right over the land to me. And this is the...
Very well. We have heard learned counsel for the parties at length. Stop. Hearing is concluded for all practical purposes. Stop. Paragraph lists the matter under the heading for orders on Wednesday at the top.
Pray for this, my lord. Until Wednesday, my lord, let the order cut.
Mr. Mitra, we are not inclined. We are not inclined. But we would, Mr. Mitra, out of deference, the appeal is pending. We are going to dispose of the appeal.
Go there and, my lord, tell my lord that
is on Wednesday. We are passing the order. Till then, please don't.
Yes, yes. On the last occasion also, my lord, I've said.
Therefore, in effect, yes.
Till Wednesday.
Wednesday.
I am obliged.
You?
আমার টাকাটা দিয়ে দিলে আমি চলে যাই।
মেলটা তো ঠিক দিয়ে এটাও
Item number 224.
আমি পিছন ঘুরে দাঁড়িয়েছি।
one thing the judgment of Justice S.B. Sinha we may refer to. You may consider it if you want to make any submission on Wednesday, only on that. AIR 2008 Supreme Court 2291.
Yes, but that is reported also in Supreme Court cases. I
Yes.
shall take it. AIR 2008 Supreme Court.
It is as we read it against your client.
Everything is against my.
Can I have the page number once?
2008-11 SCC.
My brief has gone, my lord.
2008-11 SCC page 1.
Oh, I see. 2008-11.
You are for? Mr. Banerjee has appeared. You are for?
No. In the next matter.
In the next
Oh, next matter. I see.
Yes, not. Just also refer to one judge.
এই ওরা কি দেখাচ্ছে শুনে? ও আচ্ছা, না ঠিক আছে।
As it varies, it will be a small fault. I'll give a copy.
Doubt.
Yeah.
তোমরা কি করছো? I don't understand.
Paragraph 12 and 13 may be taken.
Statement কে ধরে বসে থাকলে আমি তো
ঠিক আছে, next.
Item number 224.
Give it. Give everything.
There is a division bench judgment I find by your lordship, Justice Banerjee, sitting with Justice Oshim Kumar. As for the that original that here. And that was considered, and your lordship had also delivered a judgment where that paragraph 8 of Yakia is moving. God in respect of property.
That judgment, I authored the judgment. Must be wrong. Must be wrong. আর কি দিচ্ছে ভাই?
in between matters আটকে রয়েছে।
বন্ধ করতে পারি।
একটু কাট রিট্রে
It's almost midday, so we'll just go for 5 minutes.
I was just going to suggest to your lordship, my lord, so that we can arrange our brief. I've forgotten who I am appearing for.
I will remind my learned.
In Jessup, in Jessup.
My lord, because I the one my lord who wants the appeal to be heard out.
কি হলো? উঠবো? আমরা ঠেলে উঠে চলে যাই। We'll come back.
Item number 224.
I am for the Edelweiss, on whose application the matter was transferred. But I'm the only secured creditor. I have about 425 crores against this company. I've also filed a Section 7 application before the NCLT. And on my application, the matter was transferred. There are 3 appeals which have been filed. One by a security agency, one by the promoters, and one by the workmen. Appeal against the order of transfer. So I'm resisting it there. And there are judgments which I've also indicated in last occasion when it was being heard of this honorable court, saying that the court has the power to, or rather, yes, court has the power to transfer. And the Supreme Court says unless it's something irreversible, it will be transferred.
Yes, it has a duty to transfer.
Duty. It only requires an application, which we had made an application. Language says on the application.
You are for?
I am for the security agency appointed by the official liquidator on the basis of order of this court. I have nothing to say about the, my lord, the order impugned. I was saying my submission before the court below was that kindly pay my money. I am discharging my duties from 2019. Entire dues are there, my lord. I have given photographs that
How much? How much?
it's 4 crores and 50 lakhs, my lord.
You have filed an appeal.
Yes. I made an application before the court also, before the court below also. I have let them pay, my lord. I go walk out. I have nothing to say about this transfer. But on the basis of a court's order, I was appointed. Today, my lord, I am told that you go before the NCLT, file your claim as an unsecured creditor after the CIRP proceeding after haircut. Instead of 4 crores 50 lakh, you take 4 rupees and 50 paise. That is the idea. This I am trying to.
And
there are decision or division bench. I shall rely on a division bench decision of this court which says that no, they should be ballot paid.
I appear on behalf of item number 4.
Yes, on behalf of whom?
Workers. On behalf of the workers, I filed appeal under the order of the court. Order of the court, there is the direction for payment of the creditors, and with the workers appeared, and the under agreement, they have paid 30% of our dues, and 6% are due. They have given the time for paying, but since the order of transfer has been made, our payment has been stopped.
Today, all we are concerned with is whether the order of transfer is bad in law. Argue on that.
Yes, ma'am.
Whose appeal shall we hear first?
I am appearing for one of the appellants. I don't know any other appeal.
So the 3 appeals, one by Mr. Mitra's kind, who says he's not interested in the transfer.
He's only interested in money.
My learned friend also, workers also say.
Interested in staying before your
Yes,
lordship, not to be transferred.
Who are you?
I am a contributory and creditor of the company. And I'm submitting to your lordship the person who is applying for transfer has no locus standi to apply. Because
the secured creditor.
Because my lord, he has stood outside the white room. Specifically recorded.
So yes. Who shall address us first?
Yes.
I am quite happy to address first, but my one submission would be kindly dismiss the appeal, so that we can go on.
Before you do that, let me see whether I can sustain the appeal or not. Well, dear lordship will please to.
Shall we go through the order once?
Yes, well, yeah, I think that's the best. Well, may I? Yes, it is, my lord. I'm giving a lot of the impugned order in its, my lord, volume. Volume 2, page 214.
Yes, we'll read it from the memo.
Memo, very well. Well, does your lordship want me to place it before lordship?
We will just go through it hurriedly.
Your lordship.
We will have.
বলতে হবে হ্যাঁ Page 31 only. ঠিক আছে। Yes, that's right. 34. তুই একটু বলে দিও কারণ আমি ভুলে গেছি সব।
অর্ডার তো একটাই।
I think that yes, I think that interview. Yeah, very definitely.
Yes. Your Lordship, my lord, my first submission will be before your Lordship that kindly look into section 434 once. For this one.
You are the contributory who opposed the application before the learned single judge.
Yes.
Learned friend is the contributor.
Yes, yes.
Yes, I am.
You are the applicant, yes.
I'll just take my lord's leave, my lord.
He applies for transfer. And I say that you cannot apply for transfer. And also in course of submission, we submitted before the court that an irreversible situation has arisen in the facts of this case, which we explained to the learned judge. So, my lord, the proceeding should not be transferred. This was our submission. To the contrary was submission of Mr. Banerjee. And my lord, my learned friend, Mr. Shuddhan Petrus, my lord, his client said that I've got certain dues, certain amount of pay. So pay me and do whatever you like. So, my lord, I will submit to your lordship, my lord, that kindly look into this section 434.
1C.
4.3, yes.
1C is quoted in the judgment.
In the judgment, your lordship kindly says. It says, well, if I may place it, 434.1C. 434.1 is, on such dates as may be notified to the central government in this behalf, all matters, proceedings, or cases pending before the Board of Company Law Administration, hereinafter referred to and so, Companies Act, immediately before the tribunal, and the tribunal shall dispose of such matters proceeding. Any matter, then B is any person aggrieved. Kindly come to see. All proceedings under the Companies Act, including proceedings relating to arbitration, compromise, arrangement, reconstruction, and winding up. Well, we are concerned with winding up of the companies pending immediately before such date before any district court or high court shall stand transferred to the tribunal, and the tribunal may proceed to deal with such proceeding from the stage before their transfer, provided that only such proceeding relating to winding up of the companies shall be transferred to the tribunal that are at a stage as may be prescribed by the central government. Then provided further that only such proceeding relating to cases other than winding up for which the orders for allowing otherwise the proceedings are not reserved for the High Court shall be transferred to the tribunal. Then, my lord, there are two other provisos. All proceedings in the Companies Act 1956 other than the cases relating to winding up of the companies that are reserved for orders for allowing or otherwise such proceedings, or the proceedings relating to winding up of companies which have not been transferred from the High Court shall be dealt with in accordance with the provision of the Companies Act. Provided also that proceedings relating to cases of voluntary winding up of the companies, whether notice or resolution, I may not be enough troubling your lordship. Kindly, my lord, come to the last proviso. Provided further that any party or parties to any proceeding relating to the winding up of the companies pending before any court immediately before the commencement of the Insolvency and Bankruptcy Code or ordinance may file an application for transfer of such proceedings, and the court may by order transfer such proceeding to the tribunal, and the proceedings so transferred shall be dealt with by the tribunal as an application for initiation of corporate insolvency resolution process under the Insolvency and Bankruptcy Code. Now, I am relying upon this particular proviso. Our submission is this, that provided further that this concept of transfer has to be initiated by a party. Who is that party? This particular proviso says this. And this proviso says any party or parties to any proceeding relating to the winding up of the companies. Our submission had been before the learned trial judge, and that was the one of the submissions, that so far as my learned friend Mr. Banerjee's client is concerned, who was the applicant, is not a party to the proceeding relating to winding up. Therefore, he could not have made the application. And if he could not have made the application, there was no application pending before the court for the transfer of the proceeding. And if there is no application pending, then, my lord, the proviso comes into operation, then, my lord, it cannot be transferred. It can be transferred only on an application. And who can make the application? And any party or parties to the proceeding related to winding up. Why we are saying that he is not a party to the proceedings is because of this. Your lordship will please to come to, kindly come to page 100. Volume 1. Well, I will have to place a few of the orders before your lordship. Kindly come to page 100 first. Here, my lord, today Mr. Ardio for the secured creditor submits that a client wants to stay outside the winding up proceedings and pursue their claim otherwise in accordance with law. Hence, it has to be taken that the secured creditor, Edelweiss Asset Reconstruction Company Limited, has no objection to the setting aside of the winding up order. Considering the fact that the applicant has been making periodic payments to the petitioning creditor, as mentioned in the order dated 18th May, the said order is to continue till further order. Then Mr. Gupta's client is directed to formulate and bring to this court a scheme. Mr. Gupta, meaning thereby Mr. Chayan Gupta, who was appearing for our client. And in fact, he is still appearing with me in the matter. And Mr. Nilanjana Adia, Miss Nilanjana Adia, was appearing for Edelweiss Asset. Mr. Gupta's client is directed to formulate and bring to this court a scheme for payment of the balance outstanding dues to the creditors, with a copy circulated in the advocate's on record. Then, my lord, the next order is at page 102. This is, my lord, dated 18th May 2017. And this said that this is an application by one Shujit Dottorai, a contributory to the company. It's under section 466 of the Companies Act. He wants the winding up order against the company to be set aside and the company to be revived. It may be noted that at the time of winding up, order was passed on 6 March 2017. No secured creditor appeared before the court. The applicant has settled the claim of the petitioning creditor at rupees 10 lakhs. His learned counsel, Mr. Gupta, produces remand draft of so and so. Then, my lord, this we are not really concerned. 178. Should I look what's next? 172 order, page 122. Acme, page 122. Well, kindly come to page 122. I am not troubling your lordship. This is with regard to the nitty-gritty of the winding up as to what is to be done, who is to be paid and all that. Well, kindly come to page 122. This is important. This is dated 17th August 2017. Today, Ms. Adhyo, for the secured creditor, my learned friend's client is appearing, Mr. Banerjee is appearing now, submits that her client wants to stay outside the winding up. Page 122.
It's the same order as page 100.
Page 100.
Same order.
I see, same order. My lord, I am reading at page 122. Your lordship looks at page 100.
No, you placed 100 just now.
I see, yes. That's right. Yes, quite right. My lord, this is kindly seen. This is the order, 17th August 2017. Today, Mr. Adhyo for the secured creditor submits that her clients wants to stay outside the winding up proceedings and pursue their claim otherwise in accordance with law. Now, my lord, this, my lord, takes, in my very respectful submission, my learned friend's client outside the proviso to section 434.
Orders of 178 that come in, where also the same is recorded in the decision.
Yes, quite right.
Sets of security that is outside the liquidation
And the setting aside. volume 2, na?
Directing payments to be made.
Yes.
That was resisted.
Yes. Mr. Mithu, to be honest, I'm out of touch with these branches of law for a long time. Please just educate me. This amendment that came in 2018, 7th August 2018, which you were just placing just now, 434, 1C.
C proviso.
It says what? On such date as may be notified by the central government in this behalf. Then C, all proceedings under the Companies Act, including proceedings relating to arbitration, etc., pending immediately before such date, meaning the date of notification,
right,
before any district court or high court, shall stand transferred, automatic, by operation of law.
My lord, I will submit to your lordship, no. My lord, this subparagraph C is, my lord, has to be triggered off by an application. My lord, your lordship cannot, my lord, just sit here and say that it transfer everything. Somebody has to move the court. And who is the person who is to move the court? Proviso says so. Any party or parties to the proceeding relating to the winding up of the companies pending before any court may file an application for transfer of such proceeding. I am submitting to your lordship, subparagraph C is triggered off by the proviso, by an application. If no application is made, no transfer is to be made. So, my lord, somebody has to move. A person who is to move, any party or parties to the proceeding relating to the winding up. And I am submitting to your lordship that a party who is not a party to the proceedings in winding up is not entitled to, my lord, apply. Because his application will not be an application in terms of section 434(1)(c). Proviso cannot be, my lord, read independent of the main section. And here, my lord, I will submit, as I have submitted to your lordship, at page 100, the secured creditor wanted to stay outside the winding up proceeding and pursue their claim otherwise than in accordance with law. Otherwise, in accordance with law. Hence, it has been taken that the secured creditor, Edelweiss Asset Reconstruction Company Limited, has no objection to the setting aside of the winding up order. In other words, what he is saying is, if, my lord, if there is no winding up order, then, my lord, the question, my lord, of that, this is what is being to be transferred is all proceeding in the company, including the proceeding related to arbitration, etc. Now, this will not be, so far as he is concerned, he says that I don't want to be in this proceeding.
Notice issue. There is a transfer. Irreversible. সেই তো ভাবছি।
এইটা ডিসেম্বর 30 এই অর্ডারটা কোথায়?
এটা 270 হ্যাঁ
December 13, 4 থেকে appeal দেবে।
Yes, Mr. Mehta, sorry.
My lord, now your lordship kindly comes to page 178, second volume, the division bench order.
Hey, second volume. 178.
My lord, this was an appeal preferred from an interim order passed on 13th December 2018 for release of funds. Now, in course of this judgment, my lord, of the division bench, this, my lord, your lordship kindly comes to page 179. Second paragraph. The grievance of the appellant is that despite the appellant having engaged security personnel to protect the assets of the company in liquidation since on or about 2017, no payment have been made to it. I think Mr. Surojit Mitra's client.
Yasmin is your client?
Yeah, I think. The grievance of the appellant in that this.
They were earlier appointed, then they moved to what?
What is your client's name?
Shopsi Security Service.
Well, then kindly come to this. The directions have been given with regard to the payment. Next paragraph at page 179. The order impugned was passed on a petition under section 466 of the Companies Act by the contributories. The petition is yet to be disposed of. Pursuant to the direction issued by this appellate court, the secured creditors of the company in liquidation have been served. According to the official liquidator, the only two secured creditors of the company in liquidation are Edelweiss Asset Reconstruction, Mr. Banerjee's client, and ASREC India. Both Edelweiss, well, kindly note this, both Edelweiss Asset Reconstruction Company Limited and ASREC are represented. Both sets of secured creditors seek to stand outside the liquidation and are pursuing their claims before the Debt Recovery Tribunal. In fact, my lord, they are pursuing and they have still been pursuing. So, my lord, once they do that and they say that we do not want to be a part of the winding up proceedings, then, my lord, I submit, my lord, this proviso goes out of the picture. They are not, they no longer can be applicant to, my lord, initiate the proceedings for transfer of the winding up matters which were pending in this court to be transferred before the NCLT.
Ordinarily, who will be a party to a winding up proceeding? Petitioning creditor?
Petitioning creditor.
Who else?
The company.
Company?
Yes.
And the workers?
The workers will be.
Workers.
Workers will be there.
And the creditors?
Creditors, contributories, they can be.
This is what the learned judge said. It's a proceeding in the nature of in rem proceeding. Therefore, any creditor can apply.
My lord, if a creditor doesn't want to be a creditor of the company in winding up, then, my lord, my submission will be, can the proviso apply? Well, but the point is short, but it's very important point. Because, my lord, the power is a supreme power of the court to transfer. And 434(1)(c), had it been, my lord, by itself there on the statute book, without, my lord, that proviso, then, my lord, anybody could have applied. I am submitting to your lordship, once the proviso has been, my lord, given to this.
Can 434(1)(c) and the last proviso,
yes, ma'am,
be read together to mean that the court has power suo motu and also a party can apply?
My lord, I will submit to your lordship, my lord, subject to correction by your lordship, that in so far as fee is concerned, this is the charging section, if I may put it that way, which, my lord, empowers the court to transfer.
Court has shall transfer the operation of law, or the court has to pass an order. Court has to pass an order.
Because I should, sorry.
Shall stand transferred. That's very strong words.
Very strong word, but this has been interpreted. If you
Yes, the court retains an element of discretion.
Yes, and that has also been found on the basis of a Supreme Court judgment. This honorable court has been pleased to find that. The learned trial judge has himself held.
Yes, we've seen that.
So once, my lord, the element of discretion comes in, then, my lord, I submit to your lordship, it is not that the court has no discretion in the matter. Court has got to transfer once, my lord.
But only if something irretrievable, or what is the word? Irreversible.
Irreversible.
Ishpat ki ishpat jeno ekta? Action ishpat and Nobin steel.
Yes, quite right. Well, insofar as what I am submitting to your lordship, that is the second stage. Today, if your lordship asks me, frankly, my lord, I will not be able to say that an irreversible situation has arisen. I cannot say so. But what I am saying, submitting to your lordship, is this: when your lordship is considering as to whether that there should be transfer of these proceedings from this court to that court, one has to see, the court has to see, that is anybody asking for a transfer? If nobody is asking for transfer, your lordship cannot just sit here and say that transfer everything. What I'm submitting is somebody has to apply. Now, I am questioning the locus standi of the person who has applied. Do you have the locus standi to apply for transfer? Because once you say that I stay outside winding up proceedings, you are not a party to the winding up proceedings. And if you are not a party to the winding up proceedings, then, my lord, the main provision of section 434(1)(c) does not apply. And this, my lord, has been confirmed not only by the trial court. The trial court says you had recorded that you stay outside it. Division bench has also recorded you stay outside it. There is one other, my lord, order I would request your lordship to see. That is, my lord, an order against of the single bench, subsequent order, at page 145.
One.
145 in volume 1. This is a judgment of Mr. J.C. Orindam Sinha. And, my lord, adjudication of this application made for altogether stay of winding up of the company is being interrupted on the issue of security being provided for the securing the property and assets of the company in liquidation. Appearing security agency had been inducted by the official liquidator on taking possession of the property and assets. By order dated 18th May 2017, the then company judge has directed the official liquidator to relinquish the physical possession of the contributory, but to remain in symbolic possession. Interim order dated 13th December 2018 contains several directions, one of which upon the official liquidator to file affidavit regarding engagement of the something office.
By the office?
By the office of further and other security guards and armed personnel. Then, my lord, kindly turn over the page. How the directions should be obtained, etc. Interim order dated 13 December 2018 was carried in appeal by security agency. Appeal court disposed of the appeal by order dated 21st January 2019. Appeal court found there are only 2 secured creditors and they who seek to stand outside the liquidation. The court has again recorded that. In this context, the relevant extract from the said order is reproduced below. And, my lord, I have already placed this. This is the judgment decision of Mrs. Banerjee and Justice Ghosh. And, my lord, it has been recorded. Both sets of secured creditors seek to stand outside the liquidation and are pursuing their claims for the appropriate debts recovery tribunal. Only one secured creditor, being Edelweiss Asset Construction Company Limited, is represented, while ASREC goes unrepresented. Then, my lord, and you see, under direction made by the appeal court, official liquidator was to convene a meeting and file report. Mr. Roy, learned advocate, appears on behalf of the official liquidator and is unable to demonstrate service of notice of meeting of ASREC Limited. He had filed report on earlier occasion. He relies on paragraph 8 of the report. The said paragraph is reproduced below. In the meeting held on 29 January 2019, Edelweiss Asset Reconstruction Company Limited, the secured creditor, opted against engaging any private security and declined to assume any liability toward the past or future dues, since staying outside the winding up proceedings. Again, but emphasized that in any event, the contributory should bear the security charges in terms of the order dated 18 May 2017. The representative of the Indo-Wagon Engine Limited, my client, gave no prospective proposal leading to any resolution, but leveled some vexatious allegations in a repetitive manner. The representative of the security agency sought to discharge. Well, this is with regard to security agency and their claim of rupees 8 lakhs, etc. Then again, well, the last paragraph, the report of the official liquidator that has been recorded says participating secured creditor in the meeting something position contrary to direction made by the appeal court of not accepting liability for the security. So, my lord, so far as the secured creditor is concerned, it just wanted to wash its hands off the winding up proceedings, completely stay out of it. I am not liable for payment of to the security card. And what they did in the meantime, my lord, I shall tell your lordship.
You are in the wagon.
I am in the wagon. I am, my lord, trying to revive the company, but well, I have not done anything of the sort at the moment. My lord, I will only submit to your lordship this, that the petitioner, which is an asset reconstruction company, my lord, had been assigned the secured debts of, my lord, there are two secured creditors of the company, Central Bank of India and Union Bank of India. And by two deeds of assignment in 2014 and 15.
It's not that the court gives the Army Act. Yes.
My lord, I'm just giving your lordship the background of my learned from Mr. Banerjee's client. My lord, they filed the application. They've originally filed the application before the company court. Then, my lord, what happened was this: they went to the debt recovery tribunal and filed original application on the basis of the assignment of debt, which had been given by the Central Bank of India and Union Bank of India. So they wanted to proceed before the DRT for the purpose of recovery of their claim. And these original applications, my lord, were allowed by DRT. And this, your lordship, and directed the recovery certificate to be issued. Kindly, my lord, take the first volume, page 34. This I am showing.
So that is the short point, Mr. Mitru.
Yes, that is the short point. I'm just showing your lordship that insofar as they are concerned, they wanted to wash their hands off. If I will submit to your lordship now, they have become a busybody, which who is trying to interfere in matters which doesn't concern.
Mr. Banerjee, the short point that we have understood is you have chosen to stand outside the winding up as recorded by a division bench of this court, several single bench orders. Therefore, you are not a party to the winding up proceeding. Therefore, under the last proviso to 434(1)(c) of the Companies Act, you could not have applied for transfer. Therefore, and without an application, the judge could not have transferred. Therefore, the order is bad.
May I just answer them if my learned friend is finished? I can answer them.
Would you answer all three appellants together?
Yes, I can.
Better
Not
to
Lord,
do?
if because my learned friends, my Lord, submission is something different.
Yes, he only wants money.
He only wants money, which he can get there, my Lord, as my Lord, part of CRP.
He says he'll get 4.5 rupees.
CRP cost, my Lord, everything is.
I will show you.
CRP cost, everything is
CRP
given.
cost
Provided,
also.
my Lord, CRP cost. My Lord, that is, my Lord, my answer, my Lord, Mr. Mitra's point. First of all, there was an application.
আমি এখন
I'm for the workmen.
Third appellate.
Then leading.
Oh, yes.
I'm the third applicant.
Very well.
Third applicant for the workmen. I have a slightly different take on it.
Very well. We'll hear you.
So then, my Lord, I can wait till, my Lord.
Yes, better. Yes.
Hopefully, my Lord, I'll have answers to, my Lord, Mr. Mitra's points. My Lord,
Mr. Yes.
Yeah. My lord,
Please complete, then Mr. Mitro, then Mr. Shaha.
And my lord, today your lordship will be pleased to hear it.
Only half, the first
Only
half.
My lord, I shall be very grateful to your lordship.
I don't think Mr. Mitra wanted it after two as well. So
You are going to the abode of peace.
Not really. No.
Very hot now.
9 তো ছুটি আছে শুক্রবার।
No, that is 9, 10th, 11th, 12th.
Yes, that's
4
right.
days.
4 days holiday. We shall think of that. But today I am going to be grilled. So my lord,
Oh, reflections, or whatever it's called. Yeah. And who will grill you today?
Mr. Shah.
Mr. Jishnu Shah.
last time I missed it.
My wildest imagination is the expression grill again.
Well, I had to ring him up. Said, why is it that you are not telling me how you are going to grill me? And in fact, he was sitting in Shillong, in the cool climates of Shillong, and my lord, he was, I don't know what he was doing.
Yes.
Lordship, my lord, I will just show your lordship and then I shall take your lordship, my lord, into the decisions which I want to rely upon. My lord, 2 things I want to kindly come to volume 1, page 34. This is the Debt Recovery Tribunal order. Lordship will be pleased to come to page 34. The judgment has been delivered on 11th January 2017. I am not troubling your lordship with the judgment. It starts at 35A, and my lord, it continues. And then I will take your lordship to page 43. No, not 43.
Judgment is of 17 January, wrongly typed.
Yes.
As often happens.
17 January or my lord 11 January, I don't know, page 35A.
So if you look at 34, the original, not typed copy.
I see.
At the top, order number 22 by 17/117. Anyway, neither here nor there.
Yeah. Well, at the top of the judgment, which is delivered at page 35A, I find 11th January. But be that as it may, it goes on, and lordship will be pleased to find that the order is at page 46.
Shall we release our other friends? Your other friends, Mr. Chaudhuri is waiting, because this will continue till recess at least.
It looks like it.
Other matters released. Huh?
আমি শুনছি না তুমি কত কি বলছো My lord, kindly come to page 46A. I'm not going to trouble your lordship with the other pages. Kindly come to page 46A, the order at the bottom. The claim of the applicants is allowed with costs. And then, can you turn over the page? The reprinted page is at page 47A. The defendant number 1 is liable to pay rupees so and so as on 31st January 2014 with penalty and further damage interest thereon calculate 17.5% base rate so and so per annum with monthly rest being contractual rate of interest. It is declared the loan is secured by the hypothecation of movable and mortgage and immovable properties mentioned herein above. Pari passu with the defendant number 2 and 3, let a certified copy be issued. So your lordship sees the recovery proceedings were initiated by the asset reconstruction company as a secured creditor before the DRT, and had the DRT has directed, my lord, the recovery certificate to be issued in their favor for the purpose of recovery of this amount. So they are completely staying outside the winding up. They are proceeding against the secured assets, have obtained a decree, and they will now proceed with the certificates before, in respect of the secured assets. Then, my lord,
Certificate into operation, page 63.
and page 63, if your lordship kindly comes, they have put the, yes. Your lordship will please kindly come to page 63. They have started recovery proceedings on the basis of the certificate issued. The order is, my lord, starts at page 54 and it goes on. And, my lord, kindly see this brief description of the unit against which they are proceeding. If the plots numbers, kindly, my lord, come to, I think it's interesting. Kindly come to page 54. This is dated 31st January 2019. Learned advocates Mr. Debojyoti Saha and Ms. Pooja Chakraborty appeared for CHI. They prayed, what is CHI? Is it certificate holder institution. They prayed for appointment of a receiver to attach the properties of CD company in accordance with the petition filed by them on private day. It is observed that in spite of opportunity being given to the parties, no one filed any objection against the petition of CHI. Since CHI it should be. Since the CHI had the first charge over the properties mentioned in the petition, and in view of the report filed by the advocate of the official liquidator and taking symbolic possession of the mentioned properties is justified. In view of the prayer made by CHL, learned advocate Mr. Kamal Chakraborty is appointed as the receiver in place of the previous receiver to attach the following property. Schedule of mortgage properties had been given. I am not troubling your lordship. Kindly see plot number 1, plot number 2, page 56, plot number 3, plot number 4. Then, my lord, page 57, plot number 5, plot number 6, plot number 7. My lord, there is in Bengali, there is a saying, Gache rokhabo and tolaro kurobo. My lord, this is what is happening. My lord, they are proceeding independently, proceeding against the secured assets, and they are, my lord, trying to recover their dues. And in the meantime, my lord, they have put a finger in the pie, going before the company court and say, transfer this thing. And once this is transferred before the company law board, my lord, or rather, National Company Law Tribunal, my lord, God alone knows, my lord, where it will go. The entire thing will completely go into the, this is, my lord, what I am wondering about. What is the interest of, my lord, this particular secured creditor to send me to that court? When everybody is asking, my lord, for the intervention of this honorable court for the purpose of recovery of their dues, for the purpose of getting relief in whatever form it is possible. Once that goes over there, I think now everything will go before in the pocket of the my lord, okay? The person who will be appointed by NCLT, resolution profession. The charges will be such that nothing will remain. So what will happen is this: they will recover their dues from the secured assets, and in the meantime, the other creditors of the company, who, my lord, are seeking to get their dues from here, and the payments are being made from time to time. Anyway, your lordship, kindly see this. Kindly come to page 59.
All the land mentioned above purchased direct from the government of India and are used for industrial purposes, together with all buildings, structures, plant, machinery erected thereon. Brief description of the unit. Roller mills, then my lord, road roller preparation shop, refugee settlements, East Central States. Then my lord, structural works, boundary, page 7 is page 60. The machinery engineering works, boundary. They are proceeding against everything. They're taking away everything. Hydraulic works, page 61. And then, my lord, if your lordship comes to page 62, let warrant of attachment.
Is gone section 7 application under the IBC for initiation of solvency proceedings. আছে, আপনি বললে they will not dispute. It's fine, can't be disputed now. Section 7. After the this recovery certificate. Is it national test now? Section না না প্রথমটা চলবে প্রথমটা না Yes.
Well, kindly come to page 62. In the recovery proceedings, let warrant of attachment regarding the immovable assets be issued and provided to CHI. CHI is directed to contact learned receiver and provide full cooperation to attach property. CHI is also directed to get the properties evaluated simultaneously with that of the attachment of the property through impanel valuer and file valuation report on the next date. Then on page 63, learned receiver is directed to attach the mortgage properties and file report on the next date. I don't know what happened on the next date. CHI is also directed to file their status of movable properties and prepare a separate report in this regard to be filed before this bench on the next date. Concerned police station is directed to provide necessary police assistance to CHI to get the order executed. Copy of the order be served upon the CD through CHI. Next date on 25th April 2019. My lord, I am told that after this they have gone before the, my lord, the NCLT under section 7 of the Act, my lord, of Insolvency Bankruptcy Code, and my lord,
এই কোডটা আছে
kindly look at section 17.
ইনসলভেন্সি ব্যাংক্রাপসি না
Touch.
আচ্ছা ওদিকে একটু বানিয়ে রাখ বানিয়ে রাখ ওই তো কমার্শিয়াল কোড এটা না থাকলে খুবই
I shall give you a lordship a copy.
No, no, we have.
Section 7. Now they have independently of the winding up proceedings in this court, they have initiated corporate insolvency resolution process as the financial creditor. And my lord, they have moved a financial creditor either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor as may be notified by the central government may file an application for initiating corporate insolvency resolution process against the corporate debtor before the adjudicating authority when a default has occurred.
Shweta, this is what I was discussing with my brother. If the value of the security that a secure creditor holds is inadequate to cover his dues, can he not, after encashing the security for the balance dues,
He has gone.
So there's no bar in law.
There's no bar in law. But what I am submitting to your lordship is this: they are staying completely outside the winding up proceedings. They are completely staying outside the winding up proceedings. They are taken independent proceedings. They went before the DRT, had it recorded in the winding up proceedings that I do not want to be a part of it. Before the DRT, they proceeded. They went on to, my lord, get an adjudication in their favor. Amount was, my lord, found out. Then, my lord, the DRT directed them to proceed against this secured properties and assets. They did, my lord, proceed against that, and thereafter, my lord, they have initiated proceedings.
Now, assuming the winding up proceeding was still pending in this court,
Yes.
not transferred by the learned judge, and assuming Edelweiss, Mr. Banerjee's client, found after proceeding against the security
Yes.
that still 100 rupees is due
Yes.
from the company in
Yes,
liquidation.
my lord.
Could it not then come and file its claim before the OL?
No.
Because he did not relinquish his asset.
My lord, what happened is this: he was to relinquish his asset before coming to the official liquidator. He did not do so. What he did was he proceeded against the asset. He obtained, my lord, the order and decree from the debt recovery tribunal. He went on to execute that. And thereafter, my lord, after, my lord, they found that it is not fully satisfied. I don't know whether they have or they have not. They proceeded before the, my lord, the NCLT. Absolutely, this is, my lord, this is the proceedings for recovery of the balance amount of money that they are seeking to recover.
Must be.
And therefore, if that is so, then, my lord, they are completely washing their hands off the winding up proceedings. Then, my lord, what is the value of this proviso? Why should a person who does not participate in the winding up proceedings, not a part of the winding up proceedings, my lord, expressly, my lord, exonerate itself from the winding up proceedings, goes before a different, my lord, forum for the purpose of recovery of the debt? Why should he be allowed, my lord, to take advantage of, my lord, section 434?
Yes. And you say the company court
Yes.
did not or does not have the power to suo to transfer.
No, that was my respectful suppression. Because, my lord, the proviso is to be read with that. Somebody will apply, then the court will say, court has a discretion. Court will first look into as to whether irreversible situation is arisen or not. And nonetheless, it will have the discretion, and the court will exercise discretion for the purpose of, my lord, deciding on the application as to whether it should be transferred or not. My lord, I respectfully will submit that this honorable court has not been completely denuded of the power once, my lord, a winding up proceedings is pending before it for the purpose of deciding as to whether it will be transferred or not. It is not that the moment, my lord, this particular act has come into existence, 2013 Act, with the amendment has come into existence, the court suo motu says that you go over there. There is no power of suo motu. Otherwise, my lord, the proviso will become meaningless. And, my lord, the proviso will come into operation at the instance of a person who has got an interest in the winding up. If a person says, I don't have any interest in the winding up, you go, pursue your own remedy.
We'll stop here today. We just want to record your argument so that it helps us.
Your lordship. তোমার সিকিউরিটি গার্ডকে একটা পয়সাও দেবে না, আমরা একটা পয়সা পাবো না, সব নিয়ে যাবে। শোনো, একটা কথা বলছি, মৃত্যুদের বিশ্বাস করো না কখনো।
Correct. Sure. These three appeals are directed against a judgment and order 3:30 today.
আমি করতে পারবো না তুমি বলো তো, ওদের অসুবিধা এর অসুবিধা তোমার অসুবিধা সবাই
Live streaming is going on. করে দিচ্ছি, পরে ইনিশিয়াল করলে ইয়ে করবে, ইনিশিয়াল করলে সার্ভার করবে।
আচ্ছা
Log out.
Dismissed. Appeal is dismissed. In the event the appellant initiates arbitration or approaches any other forum which is open to her in law, including any statutory appellate forum, that forum is requested to decide the appellant's grievance in accordance with law without being influenced by any observation in this order or in the order of the learned single judge which is assailed before us.
Grateful, Lordship.
You are for?
For the appellate, my lord.
For the appellant. Still you are grateful. We have dismissed your appeal.
For the liberty, my lord, have granted.
Yes, yes. Allowed, allowed.
I'm so grateful, Minister. Deeply obliged, Minister.
No. সাড়ে তিনটের সময় সই ইনিশিয়াল করবো তারপরে
এক আলাদা কিছু লিখি একসাথে লিখতে হবে।
Who is for the petitioner, Somnath Banerjee? Oh. সবাই জানে ভয় পেয়ে গেছেন কি? Who is your senior? Moment model. Moment model. Petitioner, namely Somnath Banerjee, may find bail of rupees 1 lakh with two securities of rupees 50,000 each, out of which one must be local, subject to the satisfaction of learned Chief Judicial Magistrate Tamluk, and also on condition that the petitioner shall not intimidate the witnesses or tamper any evidence in connection with this case. And further, he shall remain within the jurisdiction of Moddomgam Police Station, excepting for the purpose of attending court proceedings. The petitioner Somnath Banerjee is further directed to meet the IC Moddomgam Police Station once in a week until further order. The petitioner shall attend the court on each date of hearing without fail. If the petitioner fails to comply with any of the above conditions as stipulated herein above, the bail granted to him shall be cancelled by the concerned court without further reference to the Honorable Court.
Grateful, Your Lordship.
It's primarily Probir Purokayastha and Vihan Singh. Primarily.
Conditions.
কাকু দেখেছো?
2, 3. 2 and 3, accept. 2 and 3. 2 and 3.
But I am for the petitioner.
The petitioners, namely Navarun Nayak and Tanusri Rai Nayak, may find bail of rupees 1 lakh each, with two securities of rupees 50,000 each, out of which one must be local, subject to the satisfaction of the learned Chief Judicial Magistrate Tamluk, and also on the condition that the petitioner shall not influence, intimidate the witnesses or tamper any evidence in connection with this case. And further, both of them shall remain within the jurisdiction of Tamluk Police Station, excepting for the purpose of attending court proceedings. The petitioner Navarun Nayak is further directed to meet the IC Tamluk Police Station once in a week until further order. The petitioner shall attend the court on each date of hearing without fail. If the petitioners or any of the petitioners fails to comply with any of the above conditions as stipulated herein above, the bail granted to them or the concerned petitioner shall be cancelled by the concerned court without further reference.
I am grateful.
Sir, sorry for your interruption, sir. For the original side, CC 48, I was called today 48, sir. Today 2 p.m. sir, I was called. Okay, I was called. Sir, what should I do, sir?
কারেক্ট, এটা তো হবে না, সেটা বুঝিয়ে দাও যে যখন
Thank you, sir.
লিস্ট কোথায়? ওই ওপরে ওপরে। হ্যাঁ হ্যাঁ ওইটাই মেল লিস্টটা। করো, হ্যাঁ আপনার সাইজ আছে, যখন হবে তখন দেবে।
Original side matter, review application item number 1 and 2.
Anandalok matter, Milad. Milad, last day, Milad had admitted my appeal with admitted the review with regard to Milad the appellate side matter. That is RBW number 360. Milad, may I proceed with that?
Proceed. We had asked for a. What are the errors apparent on the face of the record? Maybe you may have filed also some such.
Yes.
Even a chart.
And a chart.
Chart, whatever. Yes, that will do. That will do.
My lord, I beg to, my lord, lead, my lord, Mr.
Dashgupta,
my lord,
we have so many matters to cover. We very brief. If you like, you file a written note after that. You have already given us a chart indicating the errors in the order.
Very well. Milad, may I only, Milad, the appellate side matter is, Milad, the shortest one, Milad. May I proceed with that, Milad? That will not take much time. That will not take much time. That's the appellate side matter.
Which is representing the Kolkata Municipal Corporation.
Yeah, আমাকে একটা copy দিন। Milad, kindly comes to Milad the order. Milad has seen the order several times.
The memorandum of review to the.
Now, Milad, at the no, ঠিক আছে। Now, Milad, at the top, Milad will find that, Milad, the appellate side matter, Milad, is a subsequent writ. Milad, which has challenged, Milad, my client has challenged, Milad, the proceeding, Milad, they ought to have, Milad, initiated under section 397. Milad, the plan which was, Milad, approved, which was sanctioned, Milad, I had given a, Milad, a representation several times, Milad, that the plan is contrary to, Milad, the earlier litigations. The plan is contrary to the earlier plans, and, Milad, I should get a, Milad, right of hearing. Now, Milad, that right was, Milad, denied. No hearing was given. Milad, we came back to the, Milad, the honorable single judge challenging that, Milad, the no right of hearing was given. Milad, the honorable single judge proceeded on a, Milad, basis that, Milad, we don't have any conveyance or deed of conveyance or right, Milad, any document showing our title to the, Milad, property, and, Milad, dismiss the writ petition. Milad, we came back to, Milad, we appealed from the order before your lordships. Milad, when, Milad, the original side matter, Milad, recollect, was going on for number of days. Milad, it was, Milad, at least, Milad, a year later, Milad, we came to your lordships challenging that order passed by the learned single judge. Now, Milad, initially it was my lord's observation while taking up the original side matter that, Milad, will take up both the matters together. But, Milad, mostly, Milad, the original side matter was taken up. Mostly, most of the time. Now, Milad, if Milad kindly sees the order once, Milad, the memo appellate side, RBW. MAT 617. Milad, first, Milad, I have annexed, Milad, to the memorandum is order of 10th of April 2024. But prior to that, kindly comes to, Milad, the parent order.
Can দেখাচ্ছে কি দেখাচ্ছে?
Milad, can. এটা কি can তো? এটা memorandum of review. Kindly take the memorandum. Milad, memorandum will do. Milad, kindly takes the, Milad, the parent order. Now, Milad, this order of 14th March 2024 Milad, though mentions at the top MAT 617 of 2023, the first page, cost title, along with the original side numbers.
Review.
360. Review number 360 of 2000.
Milad, first is IAGA 2 of 2022, then 345, APO 28 with WPO, CAN 1, then MAT 617.
There's a delay in presenting the review that has been condoned.
That has been condoned by Lordship. My Lord admitted that by person to my Lord last order. Now, my Lord will kindly see, Milad, though my Lord had mentioned, Milad, MAT 617 of 2023, but Milad, throughout the order, but kindly don't take me amiss, Milad, throughout the order, Milad, there is no, Milad, either any observation or, Milad, my plea that, Milad, I filed a written notes before your Lordship separately, altogether separately, in MAT 617. Milad, perhaps, Milad, Milad, possibly that has not been considered, Milad, while passing, Milad, and Milad, the entire order has gone on, Milad, with regard to the original side matter only.
Matters.
There are two matters in the original side, APO 28, APO 29.
We'll hear out that appeal separately, if that is your grievance.
To
Put
that,
an end to that.
Very well, very well.
Then next.
Milad, if my Lord hears that MAT, Milad, no difficulty.
Then review application can be disposed of. We'll hear out this. Cut it short, cut it short.
Thing is, my learned friend did not point out, my lord, the point of dispute was at 700 square meters of right, and whether they had any right with respect to that or not. And so far as, my lord, this matter is concerned, everything was considered. What was not there is the number. Thereafter, my lord, the matter was mentioned, and that has also been included in the order. My learned friend perhaps has not shown that order.
No, I showed 10th April order. I showed that there is a one-line order. Kindly similar 10th April order. Kindly don't take me. That's the first order in the memo. They had mentioned subsequently. No. I showed. I appraised my lord of the first order, 10th April. Then told that kindly come to the parent order. Kindly see the first, the second, 10th April order, which my lord had observed. They had mentioned that, that their MAT number is not written in the last line.
Their grievance is that we have not discussed the appellate side appeal in the judgment. Correct?
That's the only grievance, nothing.
My lord, the matter was extensively heard and everything. The point again, my lord, revolves around that 700 square meters of line.
Only with that
you can understand what is happening. You can understand
Milad,
what
with
is
the
happening.
short grievance, we went up to the Honorable Supreme Court. Supreme Court sent us back to file.
Written notes of argument.
Written notes নাকি দিয়েছে?
Yes, Milad, we have filed a separate written note altogether. Given
exactly. Mr. Dashgupta, since you have filed written notes in that appeal also, we will pass a separate order in that.
My lord, in that, my lord, kindly give me at least 1 day time, to place the argue the mat, before a lordship. 1 day. 1 day. It is a very short matter. Only
did not argue when you argued the other two appeals?
To be very frank, mainly the original side matter was taken up.
What do you mean taken up? You were doing the matter before us.
Yes, we are doing the matter. We placed the matter before the lordship. We came 1 year later. This is a 1 year later.
In the written note, have you left out anything? Or you have included everything you wanted to submit?
To my knowledge, we have included.
Then
but give me 1 date only to read over the judgment. That's all. Only to show the judgment, the points.
Which judgment?
The points, those we have annexed to the the MAT note. Kindly show, give us 1 day, 10 minutes. 10 minutes. 10 minutes.
10 minutes or only 10?
Any day, sits 10 minutes.
Only 10
minutes.
Someday at 4:15, we'll assemble then. Someday. We are not saying on which day.
Any day,
review can be disposed of.
Disposed of with that.
কটা রিভিউ আছে? একটাই তো।
No, my lord, in this appellate side, one review.
My lord, now they want to segregate. All the three matters were being heard together.
Oh, right.
But there are two other matters. Those have been completely considered, and my lord.
এই কোনটা অ্যাপেলেট সাইডের রিভিউটা দাও তো ভাই, এত আমার সব গুলিয়ে যাচ্ছে।
RBW 360.
আমার কিছু এসো এসো। This review application is directed against a judgment and order dated March 14, 2024, as corrected by an order dated April 10, 2024, whereby 3 appeals, including MAT 617 of 2023, was disposed of. Stop. Paragraph. After the 3 appeals were disposed of, the matter was mentioned on behalf of the appellants, saying that the judgment and order, concerned judgment and order, deals only with the 2 original side appeals. Stop. The appellate side appeal has not been dealt with. Paragraph. It was in that context that we recorded the order dated April 10, 2024, and corrected the judgment and order dated March 14, 2024, by recording that MAT 617 of 2023 was also dismissed by the judgment and order dated March 14, 2024. Stop. In paragraph. In this review application, the primary grievance of the review applicants is that the appellate side matter, being MAT 617 of 2023, was never really heard, and we had heard out only the other 2 appeals on the original side. Stop. Paragraph. To cut the matter short, paragraph. To cut the matter short, we detag MAT 617 of 2023 from the other 2 appeals, and we direct it to be listed again for being heard and being disposed of by a separate judgment and order. To be listed again for being heard and being disposed of by a separate judgment and order. Paragraph. The review application, being RBW such and such, is there a connected anything? Connected.
One application.
And the connected application being such and such
are
disposed of accordingly.
The only thing is, my lord, kindly record, my lord, our submission is that, my lord, we are disputing this because it was all heard together. Elaborate submissions were made.
আচ্ছা, তাহলে ওই টু কাট দি ম্যাটার শর্টের আগে, হ্যাঁ, ওর আগে ঢোকাও একটা। Learned advocate for the respondent number?
8 and 9.
8 and 9.
Respondent numbers 8 and 9 strongly disputes the submission made on behalf of the review applicants. Stop. he says that all three matters were heard together, and the grievance of the and heard together, and notes of argument was also filed. Composite. Notes of argument were also filed in connection with MAT 617 of 2023. Stop. The grievance of the review applicants is baseless. Corporate, to cut the matter short. Yes, what about the other two now?
The other two, Milord.
Oblige your lordship, Milord, the other two matters.
By Mr. Banerjee.
Milord, I beg to lead Milord.
Indom Banerjee, Milord. He's virtually present.
Where is
virtual mode?
I don't know.
Virtual business we don't like, you know that. It's difficult. The
Milord, I am immediately withdrawing from Milord virtual attendance to the court, Milord. I am so sorry. I will, Milord, come, Milord, physically, Milord. Kindly hear Mr. Das.
No, very well. No. This has been pending for long. Very well. Tell us.
My lord, insofar as the two other review petitions are concerned,
yes,
we had Milord, tabulated, Milord, a series
yes,
of points on which
a chart.
Yes,
You've given a chart.
Now,
Yes.
with that chart, Milord, there are certain judgments we would like to rely on. We wouldn't like to, Milord, elaborate our submissions on this any further. Apart from, Milord, giving your lordships on the next date, if your lordship so pleases, my lord, a chart, Milord, the chart with the relevant portions of the judgment annexed to it, and maybe 5 minutes by the clock for us to show your lordship the chart. Nothing else. We are not going to, Milord, make any prolonged submissions.
Mr. Banerjee, you have already indicated in a chart which you have filed the errors in the order. So we have that chart.
Yes.
Now, if you wish to rely upon any judgment, kindly indicate those judgments so that we can consider.
What I would want to do, Lord, subject to what falls from your lordship, if your lordship, the day your lordship is keeping, me lord, the other review for consideration for a brief file, if your lordship can keep these two, no submissions of further will be made, my lord, orally on these two. Only, my lord, a revised chart will be submitted with the judgments.
Shuno, Kaushik.
Is, they are going to different courts and saying that the matter has been pending and they've been this review matter is being heard every day according to them in other courts, and my lord, new applications one after the other, this is being done by individual members. My lord, Mr. Banerjee is making this submission here. Your lordship has not been apprised. He filed a writ petition after, my lord, your lordship's order, my lord, a writ petition
Disclosing everything, my lord, disclosing everything. It is perhaps a trifle unfair on us to say.
Oh, sorry.
This is the problem with virtual, Mr. Banerjee. Because
I'm
you
so
wouldn't know what's happening here.
I am only hearing my lord's part of the audio.
Therefore, we are keeping it on the first available day, which is Friday, because this bench is available only on Fridays. Right? 2nd May. Come back on the 2nd of May. It is understood on that day the MAT hearing will be concluded, and all within 15-20 minutes. Because Mr. Banerjee will take 5 minutes. We'll remember that. Mr. Dashgupta, we have a lot in our hands. You have to please appreciate that. The review now, actor review disposed of. দুটো রয়ে গেল।
দুটো রয়ে গেল, অরিজিনাল সাইডটা রয়ে গেল।
Obliged, your lordship.
Obliged.
Kindly record, my lord, the tendency of the review, my lord, would not, my lord, at least create, my lord, any kind of.
My lord, we are not parties to the proceedings.
Other matters, my lord, which is pending.
But we are not parties
শোনো
to
ওই
the
অর্ডারটা
proceedings.
এটাও করো, অর্ডারেতে অ্যাপেলেট সাইডটা তো তুমি নিলে না, অরিজিনাল সাইডটা নাও, অরিজিনাল সাইডের রিভিউ দুটো বলো, একটা অর্ডার করে দিই।
My lord, we are not parties to those proceedings. We are not.
We are not passing.
That's all right. The matter is being posted.
এই দুটো ম্যাটার, অরিজিনাল সাইড দুটো ম্যাটার, লিস্ট দিস ম্যাটার্স ওয়ান।
Contempt matter item number 3.
Lord, much obliged, your lordship.
My lord, I'm for the petitioner.
তিন, হ্যাঁ। নিউ ম্যাটার না?
My lord, I'm for the petitioner. Yes, my lord. Yes, my lord. Order has
কমপ্লাইড
been
উইথ?
complied.
বাঁচিয়েছে। এই লেখো লেখো, ওটা কি? এই কি লেখো? Learned advocate for the
My lord, kindly come to the
Your
order.
lordship was pleased to, my lord, ask us to, again, my lord, give a hearing to my learned friend's client. Well, accordingly, my lord, we took up the matter for consideration by the special order building. Notices had been issued, but my lord, notice was not accepted.
My lord, kindly come to.
The recorded address notice had been sent, but it has returned back. Twice, my lord, it has been done. Then the, my lord, since your lordship was given a time bound, my lord, for consideration, we had taken up the matter for consideration. Whatever the records with us, my lord, on the basis of that, we have passed an order, taking into consideration the earlier order also. And we found, my lord, that the order which had been passed on earlier occasion, my lord, rightly passed, and that has been, my lord, separately, it was considered and recorded by the authority. My lord, this is the order. You can see, my lord, I have given a copy to him. If he is angry, my lord, he can favor an appeal. Because that was
You
the
have
occasion.
recorded in the order that the notice came back unserved.
It has been recorded in the order itself.
My lord, kindly.
And my lord, I have given the, my lord, the postal.
Then, Mr. Paul, what can be done? This gave served notice that was returned. We are not concerned why it was returned. They have passed an order now. You are at liberty to challenge that order before the appropriate forum.
My lord, kindly come to the my lord's order dated 19th December 2024, my lord. The last occasion, my lord, they have served the copy of this order, my lord.
Yes.
My lord, there is no proof at all, my lord, whether there has been served or not, my lord.
There is proof.
My lord, my lord, we are totally unaware, my lord. If, my lord, they consider, my lord, because
Go and file whatever proceeding, challenge it before the appropriate forum. They have, see, your grievance was they are not passing a reasoned order. Now they have passed a reasoned order.
my lord, no, my grievance was they are not giving opportunity for hearing, my lord.
They say they sent you
My
a
lord, that has
notice.
happened, my lord. That was happened with the beyond our
What
knowledge.
can we do, Mr. Paul? What can we do if the postal department can't find you? Esho,
My lord, if the contempt consider, my lord, once again give it, my lord.
What? Already a order has been passed. Last order kunta? December 19th. Achha. This reasoned order is December 12th.
No postal receipt is.
December 12th.
Postal, my lord, the tracking report is not available with them, my lord.
Challenge it, challenge it. Read order dated December 19, 2024.
My lord, subject to correction, my lord, the notice has been sent to the wrong address, my lord. My lord, the complaint was Priya Datta, my lord. She. My lord,
I do not know.
My lord,
All these will be open to you, Mr. Paul. All
they
these
have
points.
served the notice to the wrong address, my lord. That is
They
not.
say no, you say yes.
My lord, that is in my application, my lord. That is here, my lord. Before in the content application, my lord. Kindly consider, my lord.
Oh, stop. Paragraph. We see that a reasoned order has dated December 12, 2024. Give us a copy. Has been passed by the concerned special officer. Bracketed building. Stop. A copy of the order as filed today. Ache already.
My lord, kindly record my submission also, my lord. The notice has been served to the wrong address, my lord. The complaint was, my lord, Priya Datta, my lord. No, my lord, kindly record my submission, my lord.
Stop. Now, copies of such order were filed in court on the last occasion, and they are on record. Stop. Copies of the order were made over to learned advocate for the petitioner as recorded in our order dated December 19, 2024. Stop. The petitioner's counsel sought adjournment to obtain instructions. Paragraph today, it is submitted on behalf of the petitioner that no notice of hearing was issued to the petitioner before the order was passed by the special officer, bracket building, bracket close. Paragraph, learned senior counsel representing the alleged contemnor says that notice was issued to the petitioner at the recorded address, but the same was returned by the postal department. Stop. Paragraph, we are not inclined to enter into these factual disputes. Stop. Rightly or wrongly, comma, a reasoned order has been passed. Stop. The petitioner will be at liberty to challenge the said order before the appropriate forum, comma, in accordance with law. Stop. It will be open to the petitioner in such proceeding to urge all points, including the point of breach of the principles of natural justice, since the petitioner contends that the order was passed without granting an opportunity of hearing to him. We have recorded everything. Go and challenge it now.
My lord, one thing, my lord, they have, my lord, produced a notice, my lord, that has been served to the wrong address. My lord, kindly.
Mr. Paul, they are saying that is the recorded address. How do we, sitting here, resolve this?
So how you have come to know that it has been sent to wrong address?
From their record, my lord.
From their record,
My lord, just my senior learned friend had
Hey, paragraph CC 72 of 2024 stands disposed of.
Item number 5.
Not I have for the petitioner.
Well, on the last occasion, my lord, wrongly I had entered appearance or sought for time. Because some other matters was there, and a short time, my lord, for my lord, regarding that extension of time compliance of the order. I was not supposed to appear in this case, but someone has been already engaged. Therefore, my lord, I will intimate to them. You know, she takes it up as the next occasion, and my lord, my appearance may be ignored, my lord, on the next occasion. You know, she takes it up here.
We'll just say not today, which means next Friday.
Yes, yes.
কিছু করতে হবে না।
এই চলে এসো হয়ে গেছে কমপ্লিট সেট
Item number 4, appellate side.
Number 4, I am paying short pass for Mr. Kollol was engaged. Sorry.
Short pass over. Chalo, pass over.
Not today, Mala. I have some.
Oh.
I have some problem, my lord. I went to
Not today.
To the hospital.
Not today.
Item number 5.
My lord, I am for the review applicant in this matter.
KMC.
Well, I appeal for the appellant petitioner. Now they are review application filed by the corporation.
Only.
They have filed along with the application for condonation of delay.
My lord, condonation of delay is there. That apart, today I am the difficulty with me is, my lord, the supplementary affidavit containing the document which was disclosed, which I could get, my lord, from the client. That has been disclosed in the supplementary affidavit. That, my lord, the supplementary affidavit is misplaced. My lord, the section 5, if my lord kindly.
No, Mr. Banerjee, review we have filed bad enough, and then supplementary affidavit.
Because, my lord, inadvertently, my lord, the document could not be annexed with the stay application.
That document came into existence after
the application
no,
will come, my lord,
it
after
was
the
there, it was
condonation
not
delay
made
is allowed.
available, because from my lord's order, my lord will find that the learned advocate who was representing the corporation, he could not produce the document. And my lord,
could not produce it.
No, my lord, it is there. Your lordship knows, my lord, that will
we
prove.
Know everything and we know nothing.
No, my lord, that will prove, my lord, that.
File, my lord, the application, my lord, condonation of delay, my lord, the opposition to this application, my lord, I'll file, my lord. And also, my lord, I have filed an application for contempt, my lord, that may be also listed when the next occasion, my lord, the matter to appear in the list.
Lesho.
এটা নেবেন তো, এই contempt application-টার সাথে
This
দিতে যেদিন আসবে।
a review application has been presented, comma, directed against a judgment and order dated February 21, 2024. A review application has been presented by Kolkata Municipal Corporation, bracket KMC, comma, directed against judgment orders, whereby FMA 657 of 2022, bracketed of Shopon Kumar Ghosh versus the Kolkata Municipal Corporation and others, bracket closed, was disposed of. Stop. There is a delay of 326.
2024 my lord, was more than 1 year.
326 days.
Yes.
326 days in presenting the review application. Stop. An application for condonation of delay has been filed by KMC. Stop. The respondent in this review application wishes to file an opposition to the condonation application. Paragraph, let affidavit in opposition to the application under Section 5 of the Limitation Act be filed within 2 weeks from date. Stop. Reply thereto, comma, if any, comma, be filed within
Within a week.
within a week thereafter. Paragraph, list this matter once again after 3 weeks whenever this bench is available. You have already filed. Number
AN 556 of 2025.
paragraph, the respondent in this proceeding, who was the appellant, comma, has filed a contempt application for alleged willful violation of the judgment and order under review. Stop. Let that
CPN
matter
number
be
556. CPN 556.
553 of CPAN 553 of 2025.
556.
556 of
Of
2025
2025.
be listed along with the review application on the adjourned date. June. Upload.
পেরেন্ট অর্ডারটা দেয় আগে আগে এটা বলে না লাস্ট সার্ভিস করতে বলেছিল আই মিন ইনকামবেন্টের নামটা লিখে তার সার্ভিস করতে কত নম্বর দিলে 5 কয়েকটা রাখবো আইটেম 6
Item number 6.
No, please, Lordships, my contempt applications, that matter, Lordship would recollect. A prolonged hearing happened.
In this matter, Mr. Sondipan Banerjee is appearing on behalf of our municipal corporation. Kindly allow the short pause.
বসে নোট নে না আমি বলবো বহুদিন ধরে চক্করবাজি হচ্ছে করে বস নোট নে করলে এক বসে অসুবিধা কি আছে তো তুই তো বলার দায়িত্ব Millet, it's that matter, Millet, that yes, Howrah shop room and the ground floor, Millet, completely change of user. Yes, but the last order, Lordship will kindly take, Millet, the order dated 13th of February, Millet, 2025. Your Lordship was pleased, Millet, to direct us to serve the new incumbent, because in the meantime, the district magistrate has changed, Millet, and since over 12 years, there's no election, so there's no elected body of the corporation, Millet. So we have done that, Millet. We have got an affidavit of service which we are filing. We have already filed, Millet. Yes, yes, Millet.
Kindly allow us a short pause. A short.
He's coming, he's coming.
Millet, if he does not like Lordship will kindly, my lord, only record a one-line order, my lord, that we have already served, and let that be on record, my lord. But because otherwise they will come in again, say, and we have not received. Then we'll wait, my lord. Deeply obliged.
পাসওয়ার্ডটা কোথায় রাখবো? নিচে রাখো। হ্যাঁ, পাসওয়ার্ডটা ওখানে রেখে দাও। এটা কিছু হলো না তো ৬টা? না, পাসওয়ার্ড ঠিক আছে। তাহলে ৭টা কি?
Item number 7.
1581.
Lordship, item number 7, I am for the petition. There's a contempt application, Lordship. There's a contempt application. Lordship, as per my instruction, it has been complied with. Your Lordship's order has been complied. Yes, Lordship. Lordship. Compliance.
I'm for, my lord, we have complied with the order, my lord.
Filing a report.
Compliance.
My lord, compliance.
The advocate for the petitioner says that the order in question has been complied with.
দেখে দিচ্ছি পরেরটা। দেখে দিচ্ছি। রেডি হও। রেডি? রেডি?
Item number 8.
I am for the petitioner, my lord.
Eight and 9 ঠিক কথা। এই
Yes, Mr. Chakraborty, what is this?
My lord, I am for the petitioner, my lord. Lordship, kindly see page
The
37.
Order has been carried out. Amendment.
Carried
Amendment of the cause title.
carried out, my lord.
Carried out.
directed department to my lord undertake
Yes,
this
correct.
correction.
এটা হয়েছে সাবস্টিটিউশন না?
Substitution.
তোমার ইয়েটা কন্টেন্ট পিটিশনটাই তো খুঁজে পাচ্ছি না।
Dated 13/2/2025.
করেছে না?
To be served to us because of, my lord, the address is needed for the purpose of to facilitate, my lord, the hearing. That may kindly be directed, we'll take up the.
Lordship,
It will be compliant.
kindly see page 39 once for a moment. Page 39.
It has already been mentioned.
Yes, my lord, they have done the substitution. My
No,
lord,
my
we
lord.
require the details of that, my lord, the postal address and all this, and we'll do that.
Lordship,
They have given chance of.
Lordship, kindly see page 39 once for a moment. Learned advocate for the petitioner, second paragraph. Learned advocate for the petitioner shall furnish addresses of all the legal heirs of Kaminiwala to the learned advocate alleged container by 25/4/2023. The Board of Councillors shall issue notice of hearing to all the legal heirs of Kaminiwala. Even in spite of receipt of notice, if one or more of legal heirs fail to appear at the hearing, the Board of Councillors will still proceed and dispose of the matter. Now, on the basis of this order passed by your lordship, I have served all the addresses of the applicant legal heirs to Mr. Chakraborty. Thereafter, I have called. I am showing. Thereafter, I have attended the hearing conducted by the Board of Councillor on 12th June 2023.
I meaning I mane?
I personally, I have engaged by
You're one
on
of the
behalf of the
legal heirs.
petitioner. On behalf of the petitioner.
Is so? I thought you were one of
Sorry,
the
my
legal heirs
very,
of
very
Kaminiwala.
sorry, very kindly, sir. Kindly. I have attended on the instruction of my client. I have attended the hearing before the Board of Councillor. I have subsequently, my lord, 12 June, page lordship, page 46, my lord, page 46.
Sir, a simple question. When was that? You say page 46.
Page 46 at the letter of 6 June 2023, and accordingly all concerns shall take decision 12 June 2023. 12 June 2023.
Yes, what happened then?
Thereafter, I have submitted written notes of argument. Next page, page 47. Written notes of argument at page 47. Thereafter, no reason order has been passed by the Board of Councillor as yet. This is the situation, my lord.
Grave situation, my lord. My lord, kindly direct them amended, my lord, the petition.
Why?
Because of, my lord, my lord, since the hearing was taken place, meanwhile, my lord, here the petitioner died, substitution process was
No.
pending, my lord.
Hearing, we passed a specific order that you will hear the legal heirs. He appeared, he made submission. This is only a ploy to keep matters pending. We will direct the chairman to be present before us, Mr. Chakraborty. No, you can't take things so lightly. We want compliance within 7 days. We are keeping this matter next Friday.
My submission is, my lord, subject to correction, my lord. Let me allow to file my affidavit and, my lord, to state what is happening there and
What
the order
affidavit?
whether passed or not, my lord. Because of the pendency of this, my lord, substitution.
File your affidavit by next Friday.
My lord,
Right.
Next Friday.
only one,
Next Friday.
your lordship, whatever passing by correct, but your lordship kindly consider page 39, where your lordship.
Sir, what
specifically
we are
stated-
doing is in your client's interest.
Yes, my lord.
Please just,
Yes.
Next Friday.
we find that the department has carried out our order for amending the cause title. Stop. The legal heirs of the original petitioner, since deceased, have been brought on record. Paragraph. We find that an earlier contempt application, being CPAN 252 of 2023, was disposed of by us on April 21, 2023. Stop. The operative portion of that order reads as follows. Page 39 এখানে আমি মার্ক করে দিচ্ছি, ব্র্যাকেট করে দিচ্ছি। Paragraph. We are told that the order
হ্যাঁ ওখানে লিখে আছে সেটাই দেখলাম
Advocate for the এই কি হলো আবার
এটা নয় এটা নয়
learned advocate for the alleged contemnor numbers 1 and 2 na says that the order in question has been complied with. Stop. A report has been filed in court today. Stop. Let the same be kept with the record.
Resolution of the MIC.
Oh, sorry, report corona. A resolution of the Mayor in Council dated February 7, 2025 has been filed in court today. Stop. Let the same be kept with the records. Stop. Let a copy of that resolution be made over to learned advocate for the petitioner. Paragraph, list the matter once again on next Friday date thou to enable learned advocate for the petitioner to come back with better instructions.
What is the last order, my lord? They were direction to file a fresh report. There is no report as
Now
such.
the report
The
is
resolution. There is no report.
Yes, report. Maybe details and report.
No, kindly see the order, my lord. Kindly see the order, my last order.
I'm showing to you.
KMC will file a fresh status report. Nothing is filed.
Status report is
Become a resolution.
status of
What is done by resolution?
The rest of the original 4 and 8.
One report came.
This is the resolution.
This is the resolution that it will be done.
Yes, nothing has been done.
The approval of the proposal is made and ultimately the signature has been put by the mayor in council in the next page.
Has it been carried out, Mr. Ghosh? This is what we are.
Carried out, but it has been
No, it
done
is not.
because it's pending for consider before a lordship. That is the reason.
Next, on the next date, KMC shall file a status report.
No, positively. Three
If,
times they are taking.
if we don't say positively, that means it's not a direction.
They are not finding it, my lord. Lordship.
Maybe কি আশ্চর্য
My lord, I'm appearing on behalf of the respondent, my lord. I'm respondent 11 in person, my lord. It is a glaring example of misusing, my
আসুন
lord.
না যা করতে হয় করুন
My lord, It is a glaring example of misusing the contempt jurisdiction. My lord, without dealing my affidavit in opposition, kindly see that in the reply he has described me as a corrupted and, my lord, bribery person, my lord. My lord, without dealing the opposition of mine, my lord, he has.
Online, not possible.
My
Not
lord,
today.
It is a glaring example, my
No,
lord.
let
without-
us, let the
kindly-
affidavit on
kindly-
the last
kindly-
occasion, Lordship has directed me to file affidavits, my lord. So let these two affidavits be
Lord.
kept in the record, my lord. I am for the container 1 and 2. That is
Report-
judicial officers, my lord.
My lord, I want to submit something, my lord.
Agree.
My lord, I am Mr. Vijay Udhikari. I want to submit something. I submit. Your lordship, please allow me. My lord,
আরে বলছে তো রে বাবা, এরা পাগল হয়ে যাবে
actually,
যেতে
my
যেতে।
lord, what happens in this case, during the pendency of this, my lord, contempt application, your lordship is hearing me? My lord,
There's a
He-
connectivity issue. Please come on the next date physically. There's a connectivity issue. We can't hear you clearly.
yes. Well, what we are suffering, my lord, because
Posted it after vacation or before vacation?
Affidavit.
Yes.
Affidavit filed on behalf of
Alleged controller number 1, my lord.
alleged contender number 1. We kept with the record. Stop. Affidavits in reply filed on behalf of the petitioner. We also take petitioner's koro. We also taken on record. Paragraph. List these matters once again after 2 weeks whenever this bench is available
কাগজ আগে দেয়া আছে।
for final hearing.
but my lord, in the meantime, my lord, they have issued warrant against me. They have issued warrant. My lord, that the when the matter is pending before your lordship, it is granted by your lordship.
Please tell him to come physically and appear. We can't hear clearly. In whose name? Against whom? Yes.
By the landed additional district judge on the 17th April, my lord. The warrant has been issued.
Contempt.
In a content matter, what will we do?
Yes.
During the
Sure.
pendency of
Next
the
matter. Call the next matter.
Enough.
hearing problem. my lord.
Call the passed over matter once. একটা পাস ওভার হয়েছিল।
Item number 6, October matter.
Well, to cut the long matter short, my lord, I won't take much of your lordship's time. My lordship would recollect, my lord, this is in terms of your lordship's order of 8th of June 2023, my lord, which is assailed in a contempt application, my lord. In the meantime, my lord, there were several directions that were passed, my lord, and my lord, the order itself, my lord, prescribed, my lord, complete demolition of the ground floor. My lord, now the corporation has filed, my lord, a report, compliance report in terms of your lordship's order, my lord, which we have taken an exception that is also pending, my lord. Today, my lord, I will not, my lord, trouble your lordship much, my lord. Two things, my lord, on the last occasion also, my lord, it's been some time, my lord. I argued on two very basic principles, my lord. First is whether piecemeal compliances are possible in a contempt jurisdiction, my lord. You have to do it as a whole or you do not do it at all. There can be only two such possibilities, my lord. It cannot be done in a piecemeal manner, my lord, just to, my lord, wiggle out of, my lord, the Contempt Act, my lord. So that was one limb of my argument, my lord. And the other limb of my argument was, my lord, that the second part of the order, my lord, which was with regard to, my lord, measurements of the flats in all floor, whether any deviation has been done, that was also done, my lord. That was an order was passed, my lord. On basis of that order, my lord, there's a separate appeal proceeding pending. I am not on that, my lord. That is also, my lord, was pending before your lordship, and some of the occupiers came after the demolition happened. There was one order passed by a single judge, my lord, which is never assailed in an appeal, my lord. So all these factual aspects, my lord, are there, my lord. So it will take some time, my lord, but I do not. I have promised Mr. Mukherjee, my lord, I will take two Mr. Probal Mukherjee, my lord, I will take 2 minutes 30 seconds, my lord. No, he's not appearing, my lord, but it's a gentleman's commitment, my lord. So I will only rest here, my lord, on the with regard to my lord's last direction, my lord. We had made a compliance and we have served, my lord, the new incumbent, my lord.
You are appearing for the new incumbent also, naturally. They have served. New commissioner.
New commissioner. So Lordship will keep it on the next day, my lord. I will argue on these 2 points, my lord, and I will show from the order and from the records available.
Have you not demolished the entire
No.
structure?
Yes, my lord, I have demolished. I will come with the argument. Next argument.
Lordship, may I?
Because we are scared of your lordship's order, always, every time. So I will show that what demolition has been done. I am also
On the next
complying
day,
with
I
the
will
order of the learned single judge also, because that also protects the house of my learned brother.
Oh, my lord, single, I mean, in a single, my lord, I do not know how can it be a supervening situation, my lord, where a single judge's order can be, my lord, create an embargo on a order assailed in a contempt of a division bench, my lord, in a special jurisdiction. My lord, I do not know, my lord. I'm yet to learn a lot of nuances of laws, my lord.
Affidavit of service filed in court today be kept with the records.
My lord, we have also, my lord, prepared a supplementary affidavit, and I will also, my lord. No. Yes. Lordship will, on the last occasion also, I made a submission with regard to the sanction plan. The sanction plan that the Howrah Municipal Corp, it is his document, not my document, my lord. I cannot, my lord, give a sanction plan to my own building, my lord. It's the corporation which has to give, my lord. The sanction plan, my lord, I am bringing it on record, my lord. It is their document, which will clearly demonstrate that there is nothing sanctioned in the ground floor as flats or for shop rooms, my lord.
Stop. We see that the new incumbent in the post of commissioner, Howrah Municipal Corporation, has been served. Stop. Mr. Shondipan Banerjee, learned advocate, says that he represents the new commissioner. Paragraph. Supplementary affidavit filed in court on behalf of the petitioner be kept with the records.
We will file it.
Let a copy of the affidavit be made over to learned.
Yes, we have.
We have.
Yes.
The later copy, a copy of the affidavit has been made available to learned advocate on record for the contemnors, alleged contemnors. The alleged contemnors would be at liberty to file their response to the supplementary affidavit within 10 days from date. 10 days. Stop. List this matter thereafter, whenever this bench is available.
Deeply obliged, my lord. I will also, my lord, press my exception application to the report they have filed, my lord, and we will also, my lord, bring on record a chart, my lord. I made a small compilation of what was demolished, what is there, my lord, with photographs, my lord.
Again, this
सुरेखा तू कहाँ से आ गया? मैंने आया अच्छा किया, आया ग्राउंड में मेरे पीछे पड़ गया, यहाँ पे मेरे पीछे पड़ गया, कोऑपरेटिव में मेरे पीछे पड़ गया, हो गया, वो नहीं बात कर लिया मैंने तो deeply obliged, right? The lovely television, my lord. I'm sorry, it's not in new. My lord, IPL is going on. Deeply obliged.
Sure,
number 12.
I appear for the alleged contempt of blood. There was a direction of your lordship blood. Kindly have a look at my lord's order date 20th of February.
Beg to appear on behalf of the petitioner. This is relating to, my lord, the Panchayat Assistant Panchayat Sahayok matter of
Procedure blood.
Murshidabad. Within 4 months in the year 2023, my lord, lordship was kind enough to direct the authority to complete the whole procedure. At the very outset, my lord, they took that particular plea that everything is missing. Then honorable division bench, they have got everything. Then now they are taking differently on different occasion. And my lord, there was a direction for filing, my lord, the affidavit and all this. Our reply is also ready, my lord. Copy the
last date's order, but paragraph number 3, there is a query.
Yes.
I'm not equipped with a report. Out of the petitioners, only one of the petitioners, Lord, he has qualified to be called for the interview. Lord, I have given the name, Lord. This is a signed report of the authority. Pursuant to the direction at paragraph 3 of my Lord's order. Advertisement one by one.
One of them is there, my lord.
One of them is there, yes, yes.
Yes, and your
Only
Lordship will also.
question of maintainability, my lord.
But I've got something more. Time schedule to advertisement.
Yes, what are you filing?
Lord, I'm just assisting your Lordship by giving Lord the time schedule of Lord the entire process.
You had said, Mr. Mukherjee, on the last occasion that the result will be finally published by the end of
30th June.
End of June.
Yes, that is what is.
You still maintain that?
Lord,
Wait for 2 months then.
Lord, your
That
Lordship
we
will
recorded
kindly
in
have
the
a-
last order.
Initially direction was within 4 months.
Maybe, Mr. But we recorded that. It's an enormous task. We have recorded all that. Let this be listed in the first week of July.
Your Lordship will find Lord on the second page on 10th of June, Lord, one of the petitioner, he's supposed to appear in the interview. And I'm not bothering your Lordship with Lord the advertisement and all this that we have already
You
issued.
keep this.
Lord,
Hey,
those are
it
not
is
our part of it.
You keep it. Hey, Esho. In terms of our early
For the petitioner, my lord.
Alleged container number 1 and 3, and from the communication from the alleged container number 2, order has been complied.
My lord, it's not correct fact. My lord, what has reached to the
Every
petitioner
दिन
is
खुशी
a
है।
letter of 20th of March 2025.
क्यों खुशी ना है?
What has reached to the petitioner, my lord, is a
communication of 20th of March 2025, where it appears, my lord, we will see that they have given a post facto approval. But thereafter, my lord, nothing has been processed, my lord. Petitioner was not called for to sign on any pensioning papers. No pension has been released. Only approval has been given. It's a piecemeal compliance, my lord. It's not the entire compliance.
For the director of local bodies is concerned, well, it has already been communicated to the chairman of the Dhamdam municipality to take necessary step. Can they give municipality? Yes.
No. অর্ডারটা তো আপনাদের
Was this by this communication, the director of local bodies has requested the chairman of the Dhamdam municipality. You also represent Dhamdam chairman. Dhamdam chairman, chairman of Dhamdam municipality is contemnor in this.
No, it's not the contempt because the order was upon the state respondent.
Then state respondent has done what it could do, approve.
Approve, but
has sent
releasing of the pension was, my lord, also upon them.
Sent it to the municipality to process the pension papers.
My lord, kindly see a lordship's order. Lordship order was very specific. Appellants were directed to disburse the pension, not the municipality.
Sir, who normally does? Who disburses the pension?
Employer is the Dhamdam municipality.
Maybe, but
the pension is concerned, under Rule 31, it is the duty to release by the municipality itself from its own coffer. I show your lordship the rules.
My lord, his order is very specific. The appellants were the state respondents. Lordship has directed the appellants to disburse the pensionary benefits. Now they can relegate it to the chairman. Post facto approval has to be done by the government, and it has done it.
So, but the rules are concerned.
yes. No, Mr. Pal. Our order is there. If you were agreed by our order, you should have approached the Honorable Supreme Court. You have not done that. We don't know how you do it, but you have to do it. So we are giving you one more chance. Otherwise, we'll send for your chairman on the next date.
I'm not representing the chairman.
Oh, you're not representing.
He is representing the director of local body.
I'm not appearing also director of local bodies. I'm appearing on behalf of the finance secretary.
Yes.
We'll call for him, send for him. No problem. We'll send for him. Hey, learned advocate for the to mota kagos na. You are for 1 and
1 and 3, because 1 is no longer in the post. That's subsequently.
Right. Learned advocate for the petition for the contemner numbers 1 and 3 files a memo dated March 20, 2025, issued by the Director of Local Bodies, West Bengal, addressed to the Chairman, Dhamdam Municipality, communicating that the appointment of the petitioner in the post of residential medical officer in Dhamdam Municipality has been approved with effect from June 1, 1998. Paragraph. Now, let the memo be kept with the records. Paragraph, learned advocate for the petitioner says that thereafter, no step has been taken by the alleged contemnors or their men and agents for processing the pension papers of the petitioner, stop. Paragraph, learned advocate for the alleged contemnors says that it is the municipality who should disburse the pensionary benefits of the petitioner. Stop. This is strongly disputed by the petitioner. Stop. He says that the direction of this court in the order, violation of which is alleged in this contempt application, was on the appellants in the appeal being the state, to pay the pensionary benefits of the petitioner. Paragraph. We think that the petitioner has a point. Stop. By the judgment and order in question, we had upheld